Yeah.
And when we're done going through objections, I did have two additional ones.
Okay, all right. We'll take those out just as we're done here.
Okay, and Judge, just so my computer's not opening up as quickly as I would hope that it would. I got my cuts done for my cross via depot, but I don't even know if it was tonight or this morning. But for Mr. Cook and Ms. Kasiski's information, the pertinent pages are 166 through 174.
Okay.
And I'm going to give you the general pages because I have.
Okay.
I think that'll give you the idea of where we're going.
Sure. Thank you. Okay, I'm on 166.
And so that's for Mr. Cook. But when you're looking at their objection, I'm sorry, my first objection is to page 25.
165.
No, sorry, those are my cuts for them to look at.
Oh.
These are my objections to their cuts, and they started, my first objection is on page 25, line 10.
Line 10, okay.
I just asked that it started at line 9.
Line 9 starts with the question on line 1. Okay.
Oh.
And your objection.
It's also completeness. It's starting in the middle of a sentence.
I mean, sometimes I take out the ums and the overs and okay. And
Right, so where are we actually starting on page 25?
we started at the question, over 50 years of doing estate planning for clients, how many wills would you say you drafted roughly?
Okay, so line 9.
Right. And
Okay.
I've not seen their cuts, so I don't know where they started the video. So I'm looking at the deposition transcript itself, and all I know is that it started at you to estimate over 50 years. So it just really makes sense the way it's typed.
Oh, I got you. They got the Utah estimate.
That's fine. I just wanted clarification of.
Okay,
Let me see what the.
just take out the Utah estimate.
Take out the what?
Apparently what it says is line 10 says, what we wanted was over 50 years of doing estate planning, and what it says is you to estimate over 50 years of it.
Oh, okay. So you're actually starting at line 10, beginning with the word over?
Yes.
Okay, all right.
It looks like the clip report takes out the New Testament. Okay.
And like I said, I'm looking at the actual deposition, so I don't know.
Oh, I see, okay.
Yeah,
Yeah, I understand.
Okay,
it was
beginning.
just confusing, that's all.
All right, so there's, the objection was really just clarity
Yes.
there. Okay, so I think that's been resolved.
Yes.
Now that we know where the,
Agreed.
it's going to start at over 50 years. Okay. Next objection?
And then the next objection comes on line, page 50, line 19 to page 51. Before, objection was lodged at the deposition, compound, or form, it's leaving, it's compound, it's vague, it's confusing.
Where?
Line, page 50, line 19 to page 51, line 4.
Oh, I see. You start.
I'm sorry, page 50, line what?
19, it's at the bottom of the page.
Okay,
Okay, all right.
Objecting.
I don't understand.
The cut is this.
Yes.
They're objecting to this through line 51, line 1,
4.
line 4.
Line
They're
4.
objecting to this.
Oh, okay.
I'm sorry, so the objection is to form was,
It's the question of leading compound, vague and confusing. It's, the question is kind of in the narrative, it's just a confusing question.
I mean, and I'm happy to take it out. I mean, that's just, it was all move on.
okay, then that,
Jessica's making notes.
okay. Just for the record then, page 50, starting at line 19 through 51, ending at line A is going to be withdrawn from the excerpts now?
Yes.
Is it
Okay.
line 1?
Very good.
No. Line 21.
No.
Sorry.
I'm sorry.
What?
Page 50,
Page 50,
line 21.
Line
line
19.
21,
I'm sorry, 19.
19,
Line,
Your 51, is it line 1 or?
Line 4.
Line 4.
line 4.
oh, we didn't even get
Okay,
it.
so that's being withdrawn?
Yes.
Okay, very good. That's withdrawn. Next,
Page 62, lines 10 through
It's 10 through 14.
There was an objection lodged at the deposition. The question was, okay, was George different? Answer yes. And then Monty went on to say additional testimony, there's an objection for non-responsive, and it was for after the yes.
After the yes?
Yes.
Sustained. So that will end at yes. So the excerpt that should be allowed is the question at line 10 and the answer at line 11, yes, ending there.
I think that it's line on page 51. I need to backtrack for a second. I'm sorry, Judge, on page 51, lines 5 through 10, there was an objection to the answer after yes as non-responsive.
But I think it's okay for him to answer the question yes, and then answer the question more fully. I don't think
It was a yes or no question.
Okay.
Which one is?
So page 51, line 9. After yes, we move all of that through line 16.
Yeah, after yes, objection sustained. So lines 5 through 9, ending on line 9 at yes.
Right, and then I presume that means after yes through 16 is correct?
Yes.
Through 16.
Okay, so all jurors are finally here, but again, I'm just giving you information. We have time to go through this. It's okay. I don't want you panicking on the first day of trial.
And Judge, page 85, lines 8 through 18 discusses the 2015 will.
Yeah, I'm sorry, page 85, and would you say the lines are
8 through 18?
8 through 18?
Yes, Judge.
Okay. And the objection,
Is relevant. The 2015 will isn't up for probate. It's not an incomplete document. I think they're trying to pull in intentions from 2015 when they've made it very clear that we're really looking at the time period of 2022.
Can I respond?
yes,
Your Honor, if that's the case, what are all these? I mean, there's so many documents here that go past the time that the will was signed. They're going to say that this was Lisa's decision. This is what she wanted to do. And the fact is, Mr. Polydorus was drafting a will, worked on wills. Monty had done wills. The 2015 will was there. This is all relevant.
I think it's relevant to overrule it. Okay. And next.
Um, 87 lines 4 through 18, it's the relevance objection, Judge. This is going back to estate planning since 2008.
What is it? That wasn't.
What is it?
What page?
87, 4 through 18.
What's it?
You're on the mic.
4 through, I'm sorry, what's the ending line?
18.
18, okay, so.
That should even be.
Yes.
I don't even know why.
Yeah.
That was removed.
Okay, so this is page 87, lines 4 through 18 are being withdrawn. Is that right?
It was an error on Ms. Kasiski.
It's okay. It's withdrawn. It's not.
Imagine that. Last minute. You know, how many things has changed.
Last minute, all right, so that's withdrawn. All right. Obviously didn't get enough sleep.
It did.
I'm sensing a pattern here.
All right, and
So the next page is 131, lines 13 through 132, line 4. The issue in this is it references what they marked as MD5, which was, I believe, the Word document. And the document was not properly authenticated through their use of it. I believe they used, I think they used our base number marks produced from Lisa. And there was no, there was no business records affidavit with that because it came from Lisa, not authenticated. And then it was a Word document that they used that had, the Word version had never been produced to us.
The word, you mean the nasal format? I'm just trying to understand. Sorry.
Yeah, so when Van Pappas produced these records to us, we got, I can't remember if we got boxes, like physical boxes or boxes that were scanned and sent to us. So we never, he refers to this as the Word document. I don't think it's.
So can we identify with specificity what MD5 is?
And Judge,
Mhm.
I actually went through the first part of the deposition and went through these documents, and he admitted that he said, yes, these are my records. I brought them through the deposition. These are true and correct copies. I mean, I didn't want to do that because that would just bore the crud out of the jury, but there was like 6 or 7 documents that I did that with him.
And MD5 was one of.
I believe so. Let me see. Can you Google MD5 or search?
There we go. Do a search.
Search, Google. And we're looking for that now.
How did we do this before computers anyway?
Oh.
Your Honor, he's correct. It's on page 13.
Okay, page 13. Okay, so it was, he laid the foundation for authentication. in page
Yes,
13.
Judge.
Okay.
I am going to renew my objection on the fact that it's the 2015 will for relevance.
Yeah.
Okay, for as to relevance over.
Yeah, can we show, when we go through that, can we show that to the jury, the MD5 at the time? So I publish it, what do I do? I mean, I'm happy to publish it.
So here's, that's fine. Here's what we need to do though, is if MD5 has already been pre-admitted, you can do that. If it's not been pre-admitted, you need to lay some kind of foundation, or we can do it right now to see if the foundation has been laid, which I think, and authentication has been laid, which I think it has, but it needs to be pre-admitted before you do this. Otherwise, we're gonna have to do it during.
I understand.
And this may be something that I need to discuss after opening, because this is part of the conversation we were having about Dan Pappas records.
Okay,
Because all of these documents are in all of those boxes.
okay.
That with the business records affidavit with others, and if the court inclination is to overrule an objection on 2015 will, we have 2022 documents that we brought for relevance. So this is not a limited conversation, I guess. That might be beneficial to us to having a conversation on the admission of it. But
We can talk about it, sure.
And I guess the question I have is, they're authenticated, and we agree
Mhm.
that anything in our business record is authenticated. We acknowledge that it's relevant. What more needs to be done? That's
I
what
don't know.
it's not that, Judge. I'm saying that if we're going to talk about the admission of piece by piece documents on this after the opening, I'm just saying for the courts for going.
I would much prefer to get everything pre-admitted.
Well,
absolutely.
yes, after,
So-
I guess what I'm asking is after opening, do you anticipate giving the jury another break before a witness goes on, or after launching? Because at some point, I think it's going to be beneficial to both, all counsel to discuss it.
Yes.
Let's see this. I'm not gonna say, forged it or whatever, 2015, it's fine. I'm not gonna say that in opening, and I know that's a concern. I'm gonna say that there were versions of the will, there was one in 2015. I'm not gonna say, yeah, the will was signed. I'm not gonna do that.
Okay, and I understand the purpose for which you want to talk about it, which is intent, plan, all that kind of fun
Yes.
stuff. So, but as far as these business records, if they're authenticated, hearsay is not an issue because it was a business record affidavit. There's no objection as to relevance. Can't we just get those pre-admitted now?
I'm offering those records.
I know you are.
Okay.
That's what I'm saying, is that can we agree to admit them now? So that we don't have to worry about this later?
Yes.
Okay, so what exhibit number is that, so I can put that in my records and we can have a clear record for the court, from a court reporter?
2A was, I think.
Is this on George's list?
I don't, because I have very specific.
That version, an email, that version, and I'm not gonna use it. I'm not gonna.
I think the estate planning stuff was the first like 400 pages.
Yeah, do you want some, I think we'll have something on this judge before.
Okay.
It's not gonna be.
All right, well, so if we have an agreement on it now, and I'll make a notation here so we hear. So bizarre. I think if they're fair game, if you need to use them in opening, if you want to use them in opening, I don't know. But at some point, let's make it clear on the record which exhibit it is, so that there's no dispute. Okay, all right, so what's the next excerpt?
If I moved on to page 132, and I'm looking at the right now.
132, I'm sorry, which line?
Line 16. I'm sorry, Judge, I'm reviewing this as.
I know, it's okay, I'm not in the least concerned.
And Judge, I mean,
Yeah.
our objection is relevance. They're going back to 2015. The testimonies, in my opinion, misleading.
Okay.
And it's confusing to the jury.
Right. Okay, so irrelevant and potentially confusing, overruled.
And then page 133, 8 to 25.
8 to 25 and 133, okay.
It's, I guess, I'm sorry, it's 5 to 25. It's embedded with hearsay throughout. Do you want me to go line by line, or would you like to read?
All right, so let's go ahead and go line by line as to what you believe is hearsay, so the record is clear and I can make a ruling on each one.
Lines 5 through 12. Actually, 12.
All right, so the question is not hearsay, it's
No,
the
it's-
answer.
George called me on the day before the hospital, line 8, and told me he was in the hospital. He told me he was in the hospital. It's hearsay.
Okay, so do you have a response?
Your Honor, the response to that is, if you read all of this, it goes through the planning. Hey, I'm in the hospital, and he knows he's in the hospital. It goes to the planning of, if you keep going, it's like, hey, come at 11 o'clock. I've got the witnesses. This is all planned. And so for that reason, it would be an exception to hearsay. The other thing too is the fact that George is calling Monty is non-hearsay.
You're exactly right. It overruled on that one. Okay.
But what about told me he was in the hospital, Judge?
Is anybody disputing he was in the hospital?
No.
Okay, so the difference is that whether or not it's true, does it make a difference one way or the other?
We are not disputing he's in the hospital.
Okay, so overruled.
And then line 11, and he called me and asked me what I'm getting to, asked me if I could come to the hospital. He was ready to sign that document.
Mm-hmm. So that's future plan. That's a 803-4 exception, or 3 exception rather. Overruled.
And I told him yes.
I told you. That is one of those statements that whether or not it's true makes no difference one way or the other. So it's overruled. There's a word for that, and I'm not finding it in my head right now.
And then line 19, same objection. He asked me if I could be there between 10 and 11. That isn't dispute. I mean, we are disputing if George did this planning, and this is hearsay.
Your Honor,
That's future plan overruled.
yes, sir.
Sorry, did you say overruled?
Yes, overruled, future plan. 8033.
133, line 22. I told him, I said, George, we have to get 2 witnesses. I know exactly who I want to be the witnesses to my will. I will arrange for them to be here.
I think that goes to planning, future plans. I mean, it's not hearsay or an exception to hearsay. I mean, this actually goes to planning, he's arranging for the witnesses.
Yeah, I'm gonna overrule that one as well. That one's a close call.
Same objection, line 1, I'm sorry, page 134, line through 4. Well, let's set a definite time. He said 11 o'clock.
Goes to planning.
Overruled.
One 136, lines 22 to 25 and 137 to 2, it's the same hearsay objection, Judge.
Same thing, the planning, how did you know where to go? He told me where to go.
Overrule that objection as well. Next.
Page 138, line 7 to 13.
7 through 13. Okay. Overruled. Except for no. No, overruled. Okay, go ahead.
Same objection, 138, 20 through 23. You came in at 10:45 and George said that the witnesses would be in at 11.
That was just a question to, Matthew, and he said, yes, it's the objection.
Yeah, overruled. Okay.
Page 139,
Mhm.
lines 10 through 16. I think you were also saying that you had read the will to him. Is that what you said? Yes, I did. We went over it. I told him.
What's,
This is actually one 8034 objection or exception rather. This is definite planning of a will,
mhm.
and that can be forward or backward looking. So overruled.
Page 140.
Okay.
11 to 14.
Okay.
Maybe
12 or oh, the question is okay on 11.
I'm sorry. Yeah, that's what I'm looking back on 140.
Okay.
I'm trying to.
That's okay.
Sometimes my okay were removed. I mean, sometimes I'm good on it, sometimes.
You know, it's weird when you take a deposition, you start to see your own ticks. And I did okay a lot, and I had to be very cognizant of that, you know, but when I read my first deposition that I took and I was like, okay, blah, 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 okay, blah. We all do that. Ms. Guavati, did we give you enough time to get that? We're extemporaneously speaking to give you time to do what you need to do.
And I'm getting distracted. 140, line 8 through 16. And when it's non-responsive, Judge, do you call one or you recall whether one or the other greeted each other? They did. And George knew his name. That's not responsive to the question.
Unresponsive is sustained.
What line is that?
So that's line 8.
Line
Through
12.
16. Oh, I'm sorry, line 12.
Line 12 and 14.
Through 16.
Through 16?
Yeah.
14 and 16, okay. Oh, yeah, and through 16, sorry, yes. Well, he was responding to okay, that's, you know.
Like that. Mhm.
So lines 140, 19 through 24. It's the hearsay objection to he called him by name in response to, did he introduce you to the chaplain? Did he know his chaplain's name? Oh, yes. Then he called him by name. It's also non-responsive.
Well, he said, when he introduced you, did George know the chaplain's name? He says, yes, he called him by name. So he knew his name, he called him by his name. That's responsive.
I think it's responsive to overrule.
And the hearsay objection, Judge?
All right.
The hearsay objection as well?
Overruled.
Okay, thank you. Sorry, I didn't hear.
It's okay, no, it's all right.
The next page is 141.
Okay.
141, line 4 to 9. When the next witness walked in, if you recall, anybody greeting one another. She spoke to George and he spoke to her and he turned to me and said this, it's non-responsive, Judge, it's a yes or no question, it's all
Sustained.
And that actually lines 4 through 9.
4 through 9.
Remove
4 through 9, yeah, sustained.
I'm almost done, I think.
The only problem is the question about is optional completeness, because the next question is, okay, so after George and the nurse were greeting each other, did George turn to you and say anything? That's my favorite nurse. That's fine. That works. That makes.
Okay.
Um, And I guess based on that comment, the next line is, it seems facts upon evidence at that point.
Oh, that's.
Well, I think he can give an opinion about who's favorite. It's okay.
Well, after George and the nurse were greeting each other, Judge,
Mhm.
that's where,
Yeah, so after George and the nurse were greeting each other, did George turn to you and say anything? And
but the lines before it with the greeting has now been stricken for non-response.
Well, it is,
Right,
but
and
it just
yes.
asked the question.
he asked the other question, and he asked another question, so
Okay.
we'll let that go. Overruled. All right, next.
And then 141, 10 through 13, it's hearsay. The George terms, you would say anything, this is my favorite nurse.
I think that the facts related to that, whether that's his favorite nurse or not, it doesn't matter. He's actually, yeah.
Yeah, overruled on hearsay as well. Unless you're trying to prove the fact that that actually was.
No, I don't know. He might have just been George Bach. My favorite nurse.
I don't know, because that's why he called her to witness the will.
Oh, like a really good thing for you to examine, right?
Just throwing that out there.
Okay.
He is 141, 23 through 142, 1. The question was leading.
Agreed. Sustained.
So it's a page 141, 23 through page 42, line 1.
Lines.
Just a second. Yes, I'm sorry. There are certain questions that you have to preserve error on. You did. I missed that line, but I saw it as, okay, we're good. All right, it's okay.
Lines 142, 19 through 143, 4, hearsay objection, Judge.
It goes to intent and motive. He's saying, yes, that's my will.
Except it says, I explained to the witnesses what we were going to do, etc.
Well, I think Monty can say what he said. I don't think that's an out of court.
Let's hearsay still.
Again, Monty is he's testifying to what he said. He testified to it here in court, open court. This is what I said.
I would still object as hearsay.
Overruled. Also is an 803.4 exception to hearsay.
And then Judge, page 144, lines 6 through 17.
Okay.
Same objection, hearsay.
And same response. I mean, he's saying what he said, and it's also 803.4.
Overruled.
Judge, you're saying 8034.
8034, that's, that has to do with wills. It's plans, intent, a state of mind having to do with wills, which is slightly different than 8033, which is forward-looking intent. When you're talking about the validity of a will, or the planning of a will, that's an exception.
The reason I'm asking is because I'm looking at my technical rules right now to follow, to figure out if I have any, and it's statements for medical diagnosis.
Am I saying the wrong one? Maybe I'm.
That's part of my confusion.
I don't, it goes to, yeah, present, present.
803.
Google, Texas.
Okay.
It's on.
The answer.
That's-
Sorry, it's 8033, yes, sorry, and it is, in my handbook, it is subparagraph 4 explaining it. So that's where I got it wrong, but it's. The rules of evidence, no, you're right, it is 8033. But there's an explanation for state of mind when it's offered in certain will cases, which is both forward and backward looking to determine when the issue of the clearance will is the subject. Do you have the same book I do? Is it
Christopher has that version. I'm using my bearings right now.
Yeah.
The civil judges would love you for that.
I have both copies.
Do you? Okay.
Because that one has the explanatory notes on the fly.
Very good. It's a very good book. You have a great one there. I think Judge Garrison writes one of them.
Everything's all in one, that's what I like, for ease of carrying it.
Oh, good. Okay. All right. Next.
Page 152, 19 to 24.
152, 19 to 24. Okay.
It's hearsay, Judge.
Well, it's a portion of that, yes, I would agree, we could remove it, and it says, I said yes, and I believe we discussed some of the corporate matter I had done previously, so I don't think that relates to the will, so the and,
Mhm.
I believe, but the other, I had the original so forth, and I said yes, so the fact.
All right. With that redaction, with the withdrawal of and I believe, et cetera, over the end of that sentence, is there still an objection?
No, Judge.
No objection. Okay.
Hold on, just a minute, so I'm gonna tell Jessica, it is 152, page 23. I'm sorry, line 23, and then after yes, the rest of that answer starts with and previously, ends in previous.
So you're able to edit the video on the fly that quickly?
Oh, no, I'm just making sure.
Oh.
that With this to my tech guy, what to remove.
And then she spins it.
And then he does it.
I see.
No.
All right, sorry. All right, Ms. Lavadia, back to you.
Page 154, lines 9 through 20, Judge.
154, 9 through, which one, I'm sorry?
20.
9 through 20. Okay.
With 154.9 for, you said?
Yes.
And what's the objection?
Hearsay, Judge.
It's, same response.
And also, leading judge, there was a form objection in the deposition.
There was an objection form, but not to leading. So I wouldn't have known that that would have been something to fix.
I'm sorry, what?
There was an objection to form, but not objection to leading. And so I would not have known or had indicated.
Well, leading is one you have to preserve.
Right.
And was leading one of the objections you're raising right now?
Yes, Judge.
Okay, well, that's overruled because it wasn't preserved at the deposition. And what is the other? There was another.
Hearsay, Judge.
Hearsay.
Same response. George is still asking about this backward looking. George is still asking about what happened in the hospital. Where's the original? Do you have the original? He's asking about. Where's the one? Where's it?
Sustained as to 16 through 19.
It's 16 through 19.
Well, I guess the question too, 15, but, yeah.
Yes,
Through 20.
15.
No, 15 through 20.
15
sorry.
through 20.
15 through 20. We're all doing this.
And Judge, the hearsay objection extended to 9 through 14, is that overruled or sustained, please?
Whether he indicated something is not hearsay. It's overruled.
Thank you, Judge.
Mhm.
And that's it for me.
That's it? Really? And that covers the aligned parties as well, or does Ms. Smith have any different objections?
That covers mine.
Oh, thank you. Okay, so are we done with this?
Yeah, I assume I don't know if they have objections to mine once they get to me.
I'm not.
But I'm just-
So if we could just,
We'll try to take that up after opening, okay? We'll give them a little break after openings and we'll take the rest of it. Would that be all right?
Yes, sir.
Good. All right, do we need to talk about anything else before we bring the jury in?
No, I can.
All right, why don't y'all take a 10-minute break? We'll start openings at 10 o'clock. I'll have,
Sorry, I didn't, my two little housekeeping.
yeah, well, I'm sorry, what were those?
One was I wanted to invoke the rule.
The rule is invoked, and there is nobody in here. I don't see, let me double check on the participants part in Zoom. I don't see anybody who is a witness. I don't know if anybody's watching the Zoom video though,
Did you?
YouTube video rather, sorry, yes. So
I don't know. I've struggled with this with YouTube.
I have too.
Instruct, and we can even add.
all right, let me just see here real quick. And this is an issue all over the place, actually. So. If I.
Never.
So I don't have any indication of who is watching. There are 17 people watching. I imagine they're all students, but I have no way of verifying who is watching on Zoom. Everybody knows who their witnesses are, right?
Yes.
Okay. What you may want to do is email everybody and tell them that, they're not to participate in watching the proceedings, or I can just shut it off.
I don't have an objection one way or the other, and I would just assume that everybody's watching is
Mostly lawyers and law students.
mostly lawyers and law students, and if it's somebody else, shame on you.
Okay, so I can issue an admonishment right now to those who are watching Zoom and hang on just a second. Okay, so if you're watching on Zoom, the court has invoked the rule, which means that if you are a person who is likely to be called as a witness in this matter, you must cease watching the broadcast. And you will likely be asked that question when you're called as a witness, if you are a witness and watching. So if you're a witness, you need to stop watching, subject to potential contempt from the court, which could be very serious. Right. So I've recorded that. I don't know if you want to email your witnesses and make sure that they're not paying attention, but in the many, many times that I've done this, typically witnesses don't care. They're not watching.
Just for clarification for the record, I'm assuming that this doesn't apply to Dr. Markle, doctors Markle.
This doesn't typically apply to experts at all. Experts, and there's a split, but in this court, the experts are permitted to watch if you tell me that your expert is going to need to be able to see the testimony in order to be able to respond to it. If there's any objection to an expert being excluded by the rule, then we need to talk about that right now. Anybody have any,
I have an objection to him being excluded by the rule. I do not have an objection to them watching this.
well,
And I'm trying to-
excluded from the rule means that you're not under the rule.
Right.
You can watch. Yeah, okay, just to be clear. So no one has an objection to an expert viewing the testimony. That's maybe an easier way to hear it.
We have no objection.
No objections. Okay, all right. So experts may watch. You may email your witnesses and let them know that they should not be watching, that they will likely be asked if they've watched, and that could have a negative impact on both the trial and potentially on some could be some punitive measure there too. All right. Anything else we need to talk about? Let's see, we got the rule and what else?
There were some slides that Mr. Cook didn't need to comment on for opening,
Okay,
that were demonstratives. And so I was gonna ask you for an instruction as to whether or not we can discuss what the law is during our opening, because the only slide that I object to states testamentary capacity is determined by will and executed, which I don't think is incorrect, but I think when in an opening statement, my understanding that you present what the evidence will show, you don't need to argue what the law is until the end. And so.
does anybody disagree with that being the law? No. Okay, well, I think sometimes what people say in the opening is, because we've all seen the jury charge and you kind of, and I'm 99% there with you and you're 99% with each other. Sometimes the way that you frame it is the judge is likely going to instruct you that capacity is this. And as long as you state exactly what is on the jury charge or exactly what the law is on when it's determined, I think you're going to be okay. If you stray outside of that, I mean, you can paraphrase a bit, that's okay. But if you stray outside of it and say capacity is determined within 5 days of signing, obviously that's clearly wrong. And you can make an objection during the opening, and I will instruct the jury that is clearly not the law. And it will embarrass the attorney if you said that. So you state the law at your own peril, wherever Mr. Christopher is, he likes that. So state the law at your own peril. But I think as long as you stay within the bounds of the jury charge that we've all agreed is the law, I think you're going to be okay. Just, be careful not to go too deeply into it.
Judge, I do have one clarification.
Sir?
I think it's a little bit misleading to say, I was looking at the charge that it's determined at the time the will was signed. That's not what the charge says. It talks about not determined, but just what is his capacity. So I'm not arguing with that. But I don't want the jury to think we only look at the time of the will to determine his capacity to sign at the time of the will. So I would object to
Well, we
that not
do.
being.
Okay, so I understand what you're saying, and I understand too that there could be evidence leading up to the time that the will is signed, as long as you can prove that this condition persisted and objected on the day that the will was signed. And so even that says that you have to determine the capacity on the day the will is signed. So if that's what Mr. Cook is going to say in his opening, then in your opening, you can say, there's a little bit more to this. You can still look at, and the judge will likely instruct you that there could be evidence of some incapacity that led up to the signing of the will, and he will give you more instruction on that, how that works.
And also after too.
No, not after. After is not a thing, but I understand where you're going with your after is kind of reflecting back. Okay, so you're saying that it's part of the persisted.
It's not new, and he also got.
Right, so it's.
No.
Right, so as long as it's an understanding that it's not what happened after, but if after tends to support the assertion that it persisted prior to and objected on the day of, which I love saying that because it's just a weird way to say it, isn't it?
It is.
But that's how it is, right? That's
Well, and the only response to that is, He got sick afterwards, he had UTI infections, so it's not the same thing, so that's gonna be the problem.
I understand. I understand. But as far as opening statements are concerned, as long as we stay within that parameter, that framework, I think it's going to be okay.
That's not accurate.
Well, and that'll be the evidence. And you can certainly, if you believe that Mr. Cook incorrectly defines what or explains what evidence may be presented, you can certainly say your point and say, well, we're going to show you that blank happened before and persisted.
It's just if we're gonna argue the case, I wanted to have you for time, that's all.
I understand. So just remember, opening statement is just an outline. It's not evidence. It's just simply what you think you're going to show them. And then you better show it to them because whoever is going to be closing is going to say, remember in opening when they said blank? Well, they didn't prove that, did they? Okay. Y'all don't need instruction from me. You are all very experienced trial attorneys, and I've already admitted that many of you have tried more cases than I have, even if I include my trials on the bench. Okay. So, are we ready? Anything else?
Just a break.
Just a break. Let's take a break. Bring the jury in about 10:15. If you can, just get them lined up and ready to come in at 10:15. Everybody be ready to go at 10:15. I think what we'll do is we'll go straight to noon if we can. And just break for lunch then. We'll skip a morning break because they've already had time. Okay? All right.
Thank you.
All right.
It's at ease. Y'all can go. I'm just gonna You may all be seated. Good morning, members of the jury. How are you doing this morning? All right, so I hope you saw the snacks and colas and waters and all that kind of stuff. Is there anything missing that you would really like to have that I didn't provide? Anything? No? Okay, good. Somebody once asked me if we can have a daiquiri machine back there. And so I had to say no to that. All right, well, thank you very much. We're ready to begin. I want you to know this. Sometimes you're going to be waiting back there for a little while. It feels like, what are they doing out there? I can tell you that this group of very respected professionals has been working very hard with me. Even the week before y'all even got here, we've been working together to make sure that this is going to be as smooth and efficient a trial as possible. Make it, take up as little time as we possibly can, but giving them their ability to present their case fully and completely and wholly the way that the law requires. So I want to thank the attorneys for working so diligent with me. I know that they were working until late last night and then very early this morning also to do that. And some of the things we were doing this morning was just kind of cleaning that up to make it as efficient as possible. So we are ready to begin. Mr. Cook, I believe you're going to begin with an opening statement.
Yes, thank you.
All right.
First, I'm always surprised that everyone's back. This is opening statement. During opening statement, yesterday was more dire. We got to ask you some really general questions about some of the topics. But today what we get to do is we get to talk to you about what the evidence will show. We don't really get to make arguments. That's for later. So we just tell you, hey, this is what the documents say, these are what the people are going to say, and you've got notes. I heard the judge say this, I gave you the direction. You don't have to keep notes. You don't have to. But if you keep notes, keep them, refer back to them, and make sure that the things that I tell you are accurate and do the same for the other. First, I wanted to introduce myself. This is Jessica Kasiski. She's working with me. We talked about that. She's an attorney. We work together. My name is David Cook, and I am honored to introduce you to Lisa Polidorus. Lisa Polidorus, of course, is the surviving spouse of the esteemed Polidorus, who died about 2 years. At the heart of this story is a man, George Polidorus, who late in life found companionship, loyalty, and love. Decades after a divorce, 1976, left him single for many years. He met a woman, Lisa, who became his partner for 23 years, and for 17 of those years they were married. Let me introduce you to George. That's the one person I haven't introduced you to yet. George, there he is. Oh,
Hi.
okay. That's George Polidorus. I'm going to let everybody else describe him for you, other than just give you a very specific statement about him, but because everybody knows him, knew him in a different way. But George, to most of the world, was he was very opinionated. He knew what he wanted, and I think you'll hear Monty Donaldson will tell you he knew what he wanted, he told you what he wanted, and he didn't want to repeat himself. And so he could seem a little mean, kind of like my wife. I think she's mean, but really she's not. She's just direct. So that's who George was. That's who George was. Yesterday when we were having a little diary, I think I like to practice a little bit differently than most attorneys. What I like to do is I'm going to listen to what you guys said. And we had some very general topics. The will was signed in the hospital. There's a difference in age. But then you guys asked follow-up questions. I wrote those down. So what I want to do is answer those questions for you today. That is my goal, is just answering those questions for you. The first question was, how long were George and Lisa together, and how long were they married? 23 years, I said that a second ago, and they were married for 16 years. 23 years together, married for 16 of those years. What was George's and Lisa's relationship like? And again, I'm going to let her explain that, describe that later on, but the evidence is going to show that they were committed, they were dedicated to each other, they were very respectful of one another. As I said earlier, he was very direct, and he could be mean. She'll tell you a story about that. But with her, he had a different side. He was very soft. They had fun. borderline goofy. I mean, they would go and eat dinner, at some pizzeria just to see the guy fling the pizza. She'll tell you about Kevin, their dog. They had so much fun with Kevin. They took Easter pictures together, probably took Christmas pictures together. They just did fun, goofy stuff. And that was something I think that George didn't have in his life. He was direct. He was always talking about business. But when he met Lisa after years and years of being single, I think that's what interested him. The other thing too is that's really telling is they loved each other, yes, but they liked each other too. I mean, sometimes I tell them, hey, I love you, but I don't really like you. They liked each other. They wanted to be around each other. The evidence will show that if she was out of town, he wanted to come back. If he was out of town, she wanted him to come back. They enjoyed each other's company. Oh, that's your daughter. Okay, that's part of the case.
My,
The other question was, how did they have anything in common with such a big difference of age? The thing that you have to know is George was a young 62-year-old, when they met. He was a hunk. She enjoyed the time that they had together, and they were healthy and active. And Lisa, as much as he was, a younger person who was very healthy, she's an old soul. And I use that, I don't like to use that word, but it is a good description of who she is. She probably goes and eats at Lindy's, I don't know. But she goes to bed at 8:30. She likes to stay inside, watch TV. Her and George like to go to cheap restaurants. I mean, they didn't like anything expensive. They both had the same kind of thoughts about them, the same types of likes. And so that's what they did together, that's what connected them. How close were George's kids? And again, the evidence is going to show what the evidence is going to show. I don't want to speak too much out of turn, but look, there's 4 kids. One is Nick. Nick is not here. He is not contesting the will. The other 3, George Jr., George and Christy. George Jr. had no relationship with his dad from 2015 until the time of his death. They always had, they'll probably argue that he didn't have a rocky relationship, but it's pretty clear that George Jr. had been mad at his dad for years prior to the time that Lisa got married to George. This was nothing new. They always had conflict. And again, after 2015, George Jr. never saw his dad again. He died in 2013. I'm sorry, 2023. All right. Another thing about George is this, is that there were attempts at reconciliation. George Sr. tried to reconcile with his son. A guy named David Mintzberg tried to create a kind of space for them to reconcile. Dan Pappas tried to create some space for them to reconcile. And all of that was rejected by George Jr. It wasn't because his dad didn't want to have a relationship with him, it was because George Jr. didn't want to have a relationship with his dad. But he's here as a contestant. The other 2, Dorothy and Christy, they had more of a relationship than George, who had known at the end of the George Jr. But it was very one-sided. The evidence will show that they didn't really listen to their father. They often asked for money. And I'll give you an example of what I mean by not really listening to their father. When George Sr. met Lisa, they hit it off, immediately. And they dated for a long period, about 4 or 5 years. And then when they got married, George Sr. was excited, right? He hasn't been married for years, decades, 30 years. Longer than that? Yeah, 30 years, longer than that. And so what do? You're gonna have a big wedding, you're gonna have a party, you invite people to it, including your children. George invited his children, all 4 of his children, to the wedding. Plenty of time to show up. Nick went, he's not here. None of them went to the wedding. That was upsetting to George, you can imagine. That was a disappointment. Facts around the making of the will. Somebody asked a question, what were the facts around how the 22 will was prepared? Okay, did it just show up, like in the dark of the night? Here it is, sign this. No. This is what the evidence is gonna show. You're gonna hear testimony from Dan Pappas, from Monty Donaldson. Both of them had a 30+ year relationship with George. They're both attorneys. Dan Pappas has known George for longer. Monty knew George for a long time, and but he didn't start working on actually drafting documents until around 2014, 2015. So this will was started way back. The discussions about the estate planning started way back there. And what's interesting is Monty's using the same Word document to update all of these wills. Starts in 2015. There's some issues about a 2015 will that was signed. We don't know where the original is. Okay, there it is. Monty prepared it. It was signed. Then as time went on, George would come in, and this is the way George is, big Greek guy. He had a friend that worked in the building with Dan and Monty, and he would come in to the building, he would come into their office and say, hey guys, I want to drink coffee. So he'd come in there, he'd drink the coffee, and he would talk with any attorneys that were present. But he talked with Monty, he talked with Dan, he talked about his will and what he wanted to do, the kind of plans he wanted to make. In 2022, George got sick. We'll talk about that in a minute. I mean, it was a concern. And so at that point, George thought, what am I gonna, I want to get this will. I want to get this one finally drafted. So Lisa is at the hospital. She's there the whole time. Someday she's not there. Somebody comes to Dorothy and Christy did visit sometimes, and when that happened, Lisa left. And then she would take care of whatever she needed to do. But when she was there, George would talk with her about what he wanted, the changes he wanted to make. He would say, write this down. She wrote it down. He initialed it. She initialed it. Those documents were then transferred to the estate planning attorneys. The estate planning attorney got it, called George. Hey, George, this is what you want? Yes, that's exactly what I want. And you'll hear from Monty Donaldson. Very strong, same old George, it's always been. This is what I want. These are the changes I want to make to this will that's been going on for a long time. Okay. He went back. He made the changes, Monty. He sent the new will to George, who actually wrote on it, made changes, sent it back to Monty. Monty made the changes. So this will doesn't just show up. It's been worked on, drafted for years. Along with talking with Monty, along with talking with Dan about what he wanted to do in the estate planning. And you'll hear more about that today. The other question is, jury wants to know what's in the will. We'll talk about that. You'll hear the word residuary a bunch. Residuary. That means the residue. Whatever's left over. Okay, Lisa got whatever was left over. But the will also provided for gifts to the contestants. Now, one, George Jr., who only had about $2,500, so he was effectively disinherited by his father at that time. But they received gifts that totaled, I don't know if I can get the value right now, so I won't, but it's hundreds of thousands of dollars. I mean, so they received property under the 22 will, but they're contesting it for whatever reason. It's limited enough. Why was George in the hospital? George was healthy all the way up until the time he got to the hospital. He was strong, he was active. In 2022, early 2022, he got COVID. So they're at the dinner table, they're talking, he's a little short of breath, Lisa's concerned about him, she takes him to the hospital. He goes to the hospital, and when he comes in, they identify he has COVID. He is, there's no doubt, physically, he has real problems. He's concerned. He has problems breathing. He came in with a UTI infection. That cleared after a couple of days. But he was in the hospital for 3 months. The will falls right in the middle of the 3-month period. Okay. So it's from January to who was there when the will was signed? Was Lisa. First of all, Lisa was not there. Okay. The other 4 people in the room were one, George. He was there. Monty Donaldson, the estate planning attorney, he's known George for 30 years and what he wanted. was there. There were two witnesses. You have to have two witnesses to sign a will like this. One of them was Pastor Chuck Hawkins. We're gonna hear from him. Pastor Chuck, or Chuck Hawkins, is an individual who worked at the hospital for 15 years. I don't think he's there any longer. I think he's gone. He's worked in the hospital for 15 years. He's the chaplain who walks around and talks with the patients. And actually, Chuck came in a day or two before the will was signed. He had a discussion with George, and then George said, "Hey, why don't you come in here and serve as a witness to my will?" Nobody else is in the room. It's just George and Pastor Chuck. The other person is Jessica Laster, and I'm not sure what that relationship is, but George will say, "That's my favorite nurse." Whatever that means, I don't know. It might just be George being George. That's my favorite nurse. But that's who she is. She was there. George's state of mind. What was George's state of mind when he signed the will? And that was a great question. Because the question is when. That's what you're going to be asked. When? On that day, did he have the kind of state of mind to be able to sign a will? Now, you can consider other questions like confusion. And there are medical records. There's so many medical records. He was in the ICU for 3 months. Everything is noted. Okay? So there's going to be medical records where he is noted as being confused. That's there. Well, we have to deal with it. But what you'll see is when he came in, he had a UTI infection. Yes, he had confusion. As a result of that, they put him on what's called a delirium protocol, which just means, hey, it's for the protection of the hospitals, protection of the patient. And at night, this is mainly when you'll see the confusion. Hey, wake up, George! I gotta take the readings. He's confused at night, early mornings, but in the daytimes, there were hardly any issues of confusion, hardly any kind of notations. And they'll talk about hypoxia and oxygen ratings, but again, all of that is recorded, and we can see all of that. And on the day that the will was signed, there was no notations during that period of time when he signed. There's no notations of confusion. There's no notations that his CO2 level was, I don't think it ever got below, it was 89 and then into the 90s, average 90s after that. So the records are helpful to that respect, is that they tell you exactly what was going on at the time. The other thing is the witnesses will tell you what happened. And I'm going to read this because I want to make sure that I'm not leaving anything out. What you would hear from the witnesses about his state of mind, because they all came in. Remember, Monty Johnson, it is Chuck Hawkins, and then it's also Jessica Laster. They're the only people in the room with George. Lisa wasn't present. George's estate planning attorney, Monty Donaldson, and George discussed the will right then and there in front of the witnesses. George was alert. George did not appear confused at all. Jessica Laster added that one. At all. George did not appear to be heavily sedated or under any heavy medications. George didn't look like he was being coerced to sign the will. George was not confused. He was speaking slowly. He was not speaking slowly or losing his train of thought. He was very clear-headed. So that's the testimony you're going to hear, not only from Monty Donaldson, the person who drafted it, but these two people who are going to be called to come in who were just serving as the witnesses. Well, they're not doctors, right? They're not looking at medical reports. They're just individuals who walked in and saw what they saw, and they're the ones who are going to come in today, tomorrow, and tell you this. What also happened, fortuitously, coincidentally, is Dr. Attar, who was George's treating physician, cardiologist, right? He's a cardiologist. He came in within 45-50 minutes after George signed the will. Dr. Attar won't testify today, probably be Thursday, but he's going to say he visited with George almost daily. George made sense when Dr. Attar talked to him. While in the hospital, George was never feeble-minded. And remember, Dr. Attar typically sees him during the daytime, right? He doesn't come in and rouse him up in the morning. George made sense when Dr. Attar communicated with him. George seemed mentally with it. Dr. Attar never challenged George's mental capacity. Remember, he's a doctor. He has to communicate with him. He has to talk with him about his care. The doctor will tell you, if I was concerned about his mental capacity, I would have asked somebody about it. I would have done a test. I would have done something. He didn't do any of that. because he was never concerned about his mental capacity. How long did George live after the will was signed? He lived for about a year after his will was signed. He died at home. Okay, those are the questions that I wrote down. Unfortunately, as I told you during board diary, I can't talk to you the rest of the time. I can't find out what your questions are. You're going to have questions. They're going to make allegations. They're going to make a lot of allegations about a bunch of different stuff. And for me to even try to write it all down and try to address some of these things right now, it's just, it take the time. It's going to be too difficult. So I'm not trying to hide anything. We will address everything throughout the whole trial. But for now, I don't want to go through and try to say, they're going to say this, they're going to say this, but let me show you this, let me show you that. We don't have time for that. It's too much. Too many. Some of these allegations they may be hurtful and unnecessary. This case challenges us to consider whether or not we can honor a husband's choice, a choice made freely and thoughtfully. If asked whether we respect an individual's right to decide what happens to his or her life accumulations. At its heart, the trial is about more than just who gets what. It's about respecting the choices we make with courage and love. As we move forward, let's honor George's decisions as his final act of love and protect his right to shape his legacy with intention.
Thank you. Mr. Christopher or Mrs. Bobadia, you'll be presenting the opening. Okay, and Ms. Smith, you'll be reserving opening for your case in chief. Is that correct? Thank you very much, Ms. Bobadia.
For being here today. I know yesterday was a long day, and we also apologize for that. I'm here with Vance Christopher, my middle partner, and my client, George Jr. Also here, he's here with his sisters, Dorothea and Christy, and they're represented by Lowell Smith. First, I learned this morning that today is Greek Independence Day, which obviously for this family is a big deal. And you'll learn throughout this case that their Greek heritage is really important to George Sr. Throughout this trial, you're going to hear a lot of different information. One thing you're going to hear is that my client George, and I'm going to call him George Jr. for my sake and your sake, is probably going to be called George. I'm not quite sure of his age, I forget, but you know, his siblings and mother still lovingly call him Georgie occasionally, so don't be shocked by that. And over the next few minutes, I'm going to be talking about the siblings, their relationship with Lisa, and their dad, George. And I think Mr. Cook said it best. Everyone who knew George knew him in a different way. I think that's with all of our parents. And the picture you saw of George, that is probably how every person in this room wants to remember their father and their husband. Nobody wants to remember what he was like in the hospital in England, February, March, and April of 2022. And you'll come to learn he was re-hospitalized 2 to 3 times after he was released from the hospital in April 2022.
John Rathbush.
May. Yes, sir.
Check to the level. The fact that someone was
This is not time to check your relevance. You can hold them to their burden of proof if you think that they didn't prove up something or to make a difference, but you can cover that with witness statements.
As you heard yesterday, lawyers like to hear myself talk myself into it, and that's not a big issue, that's me. I'm saying, it's not, I didn't, that's what I'm saying, it's not, we will be objecting. And it will be me objecting, Mr. Christopher, Ms. Smith, Mr. Cook, Ms. Kusiski, and I will, her first name is also Jessica, which I would much prefer to call her by. But we have a lot of the same names in this case, so I'm going to apologize for that because there's also a witness named Jessica. But you will hear us objecting. Please don't hold it against any of us. It's our job. If it goes up on appeal, we have to make sure the record is protected, okay? So in this case, there are several parties. George's dad, obviously, he had 4 children, Nikki, his oldest, Dorothea, and Christy, and my client, George Junior, that was the youngest. And Miss Paula Lisa, is his second wife. You all know this is a will contest. It's made very clear in the voir dire yesterday. You're gonna be asked to see if George had testamentary capacity on the day that he signed the will. And the next question is whether or not he signed this will, if he wanted to sign this will, is this the day he wanted to sign? You're also going to be asked to determine if my client filed this case in good faith and with just cause. Did he have a reasonable belief to file this case? Did he have a reason to think that his dad didn't have capacity on the date the will was signed? The case, though, is more than a will. The case, and I think Mr. Cooper alluded to this beautifully, this case really is about George Senior and his family. George was very proud and supportive of his family, his children, and his wife. And I think everyone here will testify that he loved everyone dearly. I don't think anyone will say George didn't love his children or his wife. And I also don't think anybody will testify that his children or wife didn't love him. I think I'm hoping we can all agree on that. But family can be challenging. Parental relationships can have ups and downs. And you'll hear that with George, my client, George Junior. George Junior named his youngest daughter with that, Georgia. So we've got George Junior, and Georgia. And I think you're gonna hear that sometimes George and George Junior were too much alike when they butted heads. If any of you have parents who are like, probably not, or children, maybe it's your child, you understand what it's like to butt heads with your parents or your child, and it makes the relationship difficult. I think you're also going to hear testimony that there was communication in the after 2015, and it related to helping one of George's children get her Greek citizenship. And I think George was proud to help with that, because that was an important part of his life, his heritage, his Greek heritage. Then George has Dorothea, and Dorothea is sitting right there in the black jacket. She had a typical father-daughter relationship. They worked together. Dorothea has now dedicated her life to teaching, and she was in regular contact with her dad. And then Christy is the third child. Then you have 3 children like I do. The third is typically the most fiery. She was known to challenge her dad, and he was probably known to buck back. Then there's Nikki, George's oldest. Nikki is not self-sufficient. And George always worked with the family to make sure that Nikki's needs were met. And then there's Lisa, George's second wife. And although George and Lisa have been married, I think Mr. Cook said for 17 years, you'll find that she did not have a relationship with George's children. In fact, I think you'll hear later on that during some of George's sickest days, Lisa told one of the children to butt out when they were trying to talk about George's well-being. George is Greek, and it is heritage. And I know I've said that several times, but this family is involved in the Eastern Greek scene. He would love being part of the Greek Orthodox Church. He supported his granddaughter's bid for Greek citizenship. And part of that means that he believed his family was important. He wanted to care for his family. And there's going to be evidence presented throughout the trial that shows that George took his head of family very seriously. George was a businessman. Something else he was proud of, something else his children are proud of, something else I think everyone in this room was proud of. At the time of his death in 2022, he was 87 years old. He started his business ventures in or about the 70s, and he grew his business. And he was mainly in commercial real estate. And each decade, his business continued to succeed. Each of the children, George Jr., Dorothea, and Christy, worked with George throughout his business, his time in commercial real estate. He was a shrewd businessman now. And by the time he married Lisa, he was well established. Lisa's going to ask me to believe that a shrewd businessman who was working on a will in 2015 to 2022 decided one day while he was in the ICU to sign the will. She wants you to focus on February 9th, 2022. That moment in time. I think the time that he signed the will was approximately 11 a.m. Did he have capacity in that moment? The witnesses to the will, I anticipate, are going to say, yes, he did have capacity. But on what basis did they make that assessment? Did they talk to him? Did they know him? Did they have any idea of his family situation, of his assets? And on that date, he was in the intensive care unit, and you've heard this several times. He was in the ICU in Methodist Hospital. And that's when Monty Donaldson went to his room with the last will and testament. The evidence is going to show that Lisa did have contact with his estate planning attorney from mid to late January through the date that the will was signed. And you're gonna have to consider George's mental state throughout that entire time. Mr. Cook just told you that he was basically dictating terms to Lisa for his will. Did he know what he was dictating to her at that time? Did he understand it? What the medical records are going to show is that George's condition was critical. Nobody knew what was going to happen to him during this period. It was 2022, a few years after COVID, things had stabilized a little bit. But we were still in the throes of when somebody got really sick from COVID, they did know what to do. And in this case, George was eligible to be intubated, but because of the COVID protocol that they had at that point in time, they did not intubate him. And I think the experts that you hear will probably tell you that they didn't do it because it was safer not to intubate. It helped save lives. The records are going to show you that specifically around the time the will signed, his oxygen levels dropped. So when he's talking, he's fine. His oxygen levels, the record showed his oxygen levels dropped. And Monty is going to testify he sounded fine. On the day that the will was signed, George was on a mix of medications, one of which was Precedex, which is known to be a sedative. It helps to make agitated patients more compliant. He was on that for days to weeks beforehand and continued. And he was on it because prior to being administered the Precedex, George was becoming severely agitated and required medication to calm him and stabilize him. He was becoming so anxious and agitated that they had to put restraints on him during his hospital stay. And according to the medical records, he was hypoxic, which is a word you just heard. His oxygen levels were dropping. That is going to affect his overall mental state. And as anybody here knows, anybody with lung issues, oxygen levels dropping can have a severe impact. The medical records are going to show that George was consistently suffering from short-term memory loss, poor judgment, altered level of consciousness during the days up to the will execution. Lisa wants you to ignore this. Lisa wants you to focus on, by my calculation, is about a 1 hour period of time on February 9th, 2022, when the world stops and George became well aware. He was fine. He could sign a will. He understood everything. And apparently he could talk without issue. And I think Monty Donaldson, Jessica Laster, and Chuck Hopkins are probably going to testify in line with that. But the question is what did they do on that day to determine that he had capacity? Were they aware of his vitals? Were they aware of the medication he was on? Did they know what his current situation was? Did they talk to him for any length of time during that visit when they signed the will? If any of you have signed a will, it doesn't take that long. So we're talking about an hour in one day out of weeks in the hospital. The other issue in this case, and you've heard a little bit about it from Mr. Cook, is that Lisa was contacting the estate planning attorney. She wants you to believe that he executed this will of his own free act. And that he had capacity to make these decisions while he was in that ICU room leading up to February 9th. And the evidence will show that he did not. What the evidence will show is from mid-January through mid-February, Lisa took it upon herself to contact Dan Pappas' office, which is the lawyer that the office that drafted the will. And Lisa sent the terms of the will to Dan Pappas' office, and that started this process. And this is important because Mr. Cook is right. George had considered various estate planning options over the course of the prior decade. But as of February 9th, 2022, we don't know if he had a valid will. So despite being a shrewd businessman, astute in all that he did, he hadn't signed anything that was valid as of that date. So what does Lisa do? She took it upon herself to write the terms, and now is asking me to believe that George dictated these to her. Then she sent those terms to George's attorney, and George's attorney typed it up. And she did this despite knowing that George was in a fragile, critically ill, and mentally susceptible state. On or about January 29, Lisa actually texted a friend and told her, George doesn't want to talk about business or news. He just wants to be with me. Yet by February 9, he's signing the will that he supposedly told her to write the terms for. Every action that Lisa took was to ensure that a will was written and signed by George. And she took advantage of this vulnerable state in the ICU and taking the actions to draft and get the will executed. Again, when you file a contest for a will in Texas, people could try to invoke the no contest clause. And Lisa is trying to do that here today. So part of our job is to show that when George filed this lawsuit and continued it, he brought it in good faith. Like he had a reason to believe that his dad was incapacitated or subject to undue influence. And for the reasons we just discussed, I believe that the evidence will support the fact that George had reason to believe that his dad lacked capacity on the day of the will. And he had reason to believe that his dad wouldn't have financed will but for Lisa's influence. And I can honestly say, I don't think George Jr.'s relationship with his dad is what even George would have wanted towards the end of his life. I think you're going to hear that George tried to call him while he was in the hospital, but didn't get called back. I think you're going to hear that George was in constant contact with his siblings, getting updates about his father. It's not that he didn't care about his father. It's that I'm not sure that George knew how to process what was going on, knowing that he didn't have that relationship with his father. Over the course of the trial, you're going to hear various testimony from doctors, family and friends, and the witnesses to George as well. You're also going to probably bombarded with paper. The boxes over there, unfortunately, including several medical records and paper documents from the attorney's office. But it's your job to consider all of the evidence. And we ask you to do that with a clear head and open eyes, okay? As you're doing this, I'd like you to remember some key dates. January 24th, the day Lisa reaches out to George's estate planning attorney to tell him how worried she was about George. January 29th, the day that Lisa tells a friend that George didn't want to talk about business. February 1st, Lisa sends the George's estate planning attorney notes to his phone. February 8th, the day before the vote. The medical records showed he was confused and suffering from short-term memory loss. February 9th, the day the will was signed. And the following few days, where the medical records will support that he continued to have memory loss. Some key words in this trial that you're going to hear, I think, that I'd like you to keep attention on. There's, and I'm not going to try to say the formal name of this because I don't think I can. It's a medication, it's called precedents, it's a sedative. The doctor's going to talk about altered level of consciousness, with short-term memory, disorganized thinking, anxiety, poor judgment, confusion, and poor attention and concentration. Everything I'm asking you to pay attention to is going to be really important to your decision to have undue influence in good faith and just cause. At the end of this case, I hope that you see that George loved his family dearly and that his family loved him. We're not being asked to decide who George loved or didn't love, and we're not being asked to decide who George loved more. It's not about who deserves more. It's about whether or not George's will is valid, and if that will reflects his actual wishes. We all thank you for being here. And we look forward to seeing you for the next several days.
Thank you, Ms. Guabadia. Mr. Cook, are you ready to call your first witness?
Can we approach?
Oh, sure. Why don't we, maybe while you're doing that, Mr. Cook,
Oh.
move that over that way.
I don't. So,
No?
I'll just call it.
Oh, okay. All right. No reason to approach then.
Okay. sorry.
Okay, that's okay. Would you mind?
Oh, that's good.
Thank you. And your first witness is Daniel Pappas. All right. Would you please bring in Daniel Pappas? Thank you. Good morning, Mr. Pappas. Morning. Do you solemnly swear or affirm the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You may take a seat.
Good morning, Mr. Pappas. How are you doing?
Morning, fine.
Would you please turn to the jury and state your name?
My name is Daniel Pappas.
I'd like to ask you a few questions to let the jury know who you are. Where are you from?
Most of my life, Houston, Texas. I wasn't born here, but I've been here since 1971.
Okay. You married?
I am
How long?
55 years this year.
Got kids?
I do.
How many?
4 lovely daughters.
Oh, lucky. You. Did you go to law school?
I did.
Where'd you go to law school?
South Texas College of Law.
Okay, and where, for the benefit of the jury, where is that?
Downtown, it's downtown Houston. It was a night school when I went there many years ago. Now it's changed. They have daytime and nighttime classes.
Okay. When, I'm assuming you graduated from South Texas?
I did.
When did you become an attorney?
1974.
And as an attorney, what kind of law have you practiced?
Started off doing property casualty work with a larger law firm, and then changed firms and started doing more civil work as opposed to criminal work or probate work. But changed a little bit as far as the work that I had done, and then started representing plaintiffs and defendants, and eventually get closer. Okay. Eventually, changed to when I set my own firm about 38 years ago, 39 years ago, into more of a general practice than it was before.
Okay, And you touched on the fact that you have your own firm. I'm gonna ask you about that in a minute, but give us a sense of how long you've been practicing law.
Last year was the 50th year as far as practicing law.
And you said you have your own law firm. When did you establish your own law firm?
In 1986.
And are you still there? I mean, you still have your law firm?
I'm still there, still practicing law, and enjoying every day of it.
Wow.
Have many friends and many relations, and it's rewarding.
Okay. All right. Do you know who Monty Johnson is?
I do.
Okay. How did you meet him?
Met Monty in law school the very first year. I was in law school, I met Monty, and so that would have been 1971.
Okay. You and Monty, or have you worked together?
We have worked together for many years, probably more than 40 years. And so I know Monty very well.
Okay. Does Monty work at your law?
He does.
How long has he been working at your law?
Probably more than 40 years now. I've not counted or when he first started, but it was after law school. He went to work for another firm, and he worked for TRW for a while, and then he, I think I contacted him, and I used enough of his notes in law school where I felt like he was pretty efficient, pretty good. So I'd like to have him join my firm. So that's pretty much how we started.
Okay. How'd y'all divide up duties? What did you do? I mean, I guess were you his boss? Is that the way it is? Yes, no, managing partner?
I don't really think of it as a boss. He really had his own practice. He was older than I, and so he was had his own way of doing things. He was more the accountant. I think that's what his undergraduate degree was, and he worked in that type of practice or in that field. He did more of the estate planning, the corporate and transactional work than I did. And some of it was kind of boring to me at the time, so I was glad to have him work on that. And he developed an itch in those areas, and so he really handled that, and I handled other aspects of business, other practice.
And I know this may be a fluid question, but is Monty still working at your firm right now?
He's had some health issues, and so, especially in the last several months, he doesn't come to office that often. He unfortunately is going to have to retire, but he's 89, so he's put the time in. It's just unfortunately very difficult for him now.
Yeah. Was this more of an abrupt kind of change in his health, or was it something that's?
He's had a little bit of a decline, but it was more recent where the decline became pronounced and where it is today.
Yeah. I mean, can he even walk right now without assistance?
He has a cane and he has a neurological issue, so it's one of those with a big base, and so it's difficult.
Okay. Tell me about George Polydors. So first thing I want to ask is, how long did you know George Polydors?
Before I started my own practice, George was a client in another firm that I worked for, so I've known George for more than 40 years.
And when we say George Polydors, we're talking about George Polydors Sr.
Senior, I'm sorry. I know
That's okay, and I wasn't clear, I apologize.
No, I'll try to be clear. I know both as George, but I'll try to be specific as far as senior or junior.
Okay. And how did you first meet George? Was this personal acquaintances? Was this work?
George came to me, and I don't know how the introduction occurred, but I remember he had a case, one of the first cases that I recall is that he was in the real estate business, and there was a commission that was owed to him, and I think that eventually resulted in litigation where we could recover the commission that he was entitled to receive. But that's the first case that comes to my mind as far as where I actively represented George and pursued a case for George.
Okay, so that was about 40 years. That was about 40 years ago, but when we're talking in terms of 40 years ago, he's been gone for a couple of years, so it's 38 years prior to his death.
Well, before 1986 is when I know for certain that I knew George and had the pleasure to represent George Sr.
Okay. Were you and George, other than just business, work, client, were you guys friends?
We were.
Tell me about your friendship with George.
Um, George was a strong personality, but he knew everybody in the office. He would come in oftentimes unannounced, go back and make coffee. And if I was tied up, he'd go visit with some of the lawyers in the office. He made himself at home. Finally, when I was free or able to visit with him, he'd come down to my office and tell me what he wanted to do. But I represented in a number of things. He was in the banking business, real estate business, just in a number of different businesses. And as I said, I enjoyed the opportunity. I was glad to represent George Senior, and for many years that was it. And then because of the relationship we had, we started going out to lunch. We'd spend time visiting. He always had an opinion, so he shared it. And whether it was politics or sports, whatever, we just had a good relationship. And before he went to the hospital, we would go out at least once a month. And one of the lawyers in the office was his next door neighbor where he lived, and next to Lisa and George. And so he would join us, and we had a strong relationship as far as just good friendship. He was not just a client, but he was a good friend.
Did you know George Senior's story?
Yes, I met them all.
I'm going to ask you about the relationship between George Senior and George Junior. Were you familiar with that relationship between the two of them?
I was.
And how would you have been familiar about that relationship?
Well, more as a friend, George Senior would tell me about the relationship and how basically they had severed their relationship, and he told me about that, and I had conversations with him about that. I talked to George Jr. because I've known George Jr. About that, so I was very familiar with it. And I talked to both of them because I wanted them to patch it together and have a relationship.
And did that, let me ask, was your attempts at reconciliation, was that successful?
Unfortunately, no. I remember I talked to George Jr. and expressed to him how I thought it was very important. And I told him whatever I could do to help, I would.
He's a pardon. He's a pardon.
He's not.
Oh, I see, I understand. Okay, so you had, I'm sorry, I thought we were talking about.
Who are we talking? We're talking about George Junior's statement?
Yes.
Oh, I'm sorry, he is party.
Yes.
I don't disagree. I believe the testimony was
What he said.
what he said.
I think their conversation between each other is allowable, overruled. I'm sorry. I thank you for the clarification.
Yes.
I'll try to be clear.
That's all right. I promise you.
Yeah. We don't want to say, oh, George is young, George.
I'm sorry.
But anyway, and I'm sorry, you were interrupted. Would you, I think what you were telling jury was that you were trying to attempt to have these discussions with both of them, and then I asked you if it was successful, and you were telling me about a conversation you had with George Jr. Would you continue?
I remember it was about 5 or 6 years ago. It really bothered me because I just felt that having a relationship was important. And I wanted George Senior and George Junior to enjoy the relationship that I had with my parents. And I told George, there's going to be a point in time where George Junior,
I'm sorry, George.
that
Objection, hearsay again.
It is, he's talking about his statement to George Junior, who is a party opponent. Overruled.
I told George Junior that there's going to be a time where you're not going to have a father. You can't patch that relationship together. You can't tell him that you love him. He'll be gone. My parents were both deceased at that point in time, so I know how important that was or is. And I tried with George Junior and George Senior, worked on both of them because I felt like it was so important. It meant a lot to me.
Mm-hmm. Okay. Let's talk about George is planning, what he wanted to do with his property upon his death. You weren't the estate planning attorney, correct?
That's correct.
So you weren't the one who would have typed the will up, made any changes. That's not who you were. That's not what you did for George. Is that right?
That's correct.
Okay. Who did that work?
Monty Dobson.
Okay. As his attorney, and working with Monty pretty closely, it sounds like, did you ever talk with George Senior about what he wanted to do with this property?
Many times.
Okay. Starting when do you think that you started having these conversations with George Senior about what he wanted to do with his property at his death?
It was a number of years. I'm going to say, I know there was a 2015 will, so it might have even been before that. But it was a number of years where George would talk to me about what he wanted, what he planned on, how he wanted to handle things of that nature.
Okay. And do you recall generally, what were those discussions? Did he say, I want to leave everything to my kids, I want to leave everything to my wife? What did, what sort of things did he tell you about his motive, his intent, what he wanted to do with his estate?
That's, for the record, objection, dead man's statute.
Dead man's does not apply to the witness. He's not party. So that's overruled. As far as hearsay, you said?
Just to be clear, I'm objecting to if he quotes George Senior.
That's not a dead man problem. Overruled.
All right. So let me ask the question again. And just say, I'm sorry. The question, I had asked you about estate planning, that you're not the estate planner, Monty is. But what I was asking you is, have you had an opportunity to talk with George about his estate planning, what he wanted to do with his property? You said yes, you started talking about it around 2015, maybe before, but you knew he had 2015. All right, and we got to back up to where we were.
I'm with you.
Okay, good. I may not be with you, I'm trying to get back to it. So tell me again, I'm gonna ask you a question. Did you talk with George about what he wanted to do with this property? And I asked specifically, as far as his estate planning desires went, did he want to give everything to his kids? Did he want to give everything to his wife? I mean, what discussions did you have with him, George Senior, about that?
George, being the analytical senior, being the analytical person he was, had very specific plans that he had in mind. Nikki, he was concerned about as far as the living arrangements and making sure that he had a place to live. But that was something that I remember that took place. And that morphed into different discussions. For instance, the property in Timmins was sold, and then there was an issue about the proceeds. And I think at some point in time, Christy and Dorothea were to be handling the financial arrangements for Nikki. I know there was a discussion about George Jr. George.
Well, let me ask you this question, because I just want to break up.
Okay.
What was this particular comments that George Senior had about George Jr. as it had to do with his estate plan and desires to give his property at his death?
Well, there's discussions about what to do because George did not have a relationship with George Jr. And we wanted to leave something in the 2015 will. Didn't want to leave anything to him, and it kind of changed. He wanted to leave something for the 4 children of George Jr. and something for George, but certainly not on the same level as, for instance, Lisa, his wife, and the other the daughters, and Nikki. So he had certain properties. I know the ambassador was mentioned many times in the different wills as far as who was going to get that. There were different properties that, again, being accurate.
Excuse me, I think we're non-responsive at this point.
I'm gonna sustain that one. So let's see if we can just keep within the theme of the question. Okay. All right, sustain.
And you were talking about, I think you were talking about the specific properties that he might have wanted to give to his daughter.
Correct.
Yeah. Would you continue?
We wanted to have them received certain property, whereas Christie was not in the 2015 will, so he could change and he sent notes.
Excuse me, Judge, can I take the witness on a very brief board hire? I have just one topic I'd like to go over. Take me about 2 minutes, may I do that?
Would you like me to excuse the jury for that, Board Hire?
No, I don't think so. I mean, I'm glad to do it either way.
We approached before.
No, come on, let's come on up. You may take the witness on Board Hire, yes. Yeah.
Mr. Pappas, Vance Christopher, I represent, George Senior. A couple of questions. One, is your testimony, you've given some answers, is that testimony based on what George Senior said, or is it based on things that others may have said, such as Monty or anybody else?
Well, the conversations that I mentioned that George Senior had with me, those are the ones that are based upon George Senior and my conversations. Conversation that I mentioned about George Junior was based upon my conversation with George Junior.
Was any of the testimony that you gave in response to Mr. Cook's question based on conversations from somebody other than the George Junior question? Anybody other than George Senior?
Those are the conversations that I had with George Senior, and so in answer to your question, those are all direct questions that I had, our correspondence communications with George Senior, except for the one about George Junior.
Did you ever talk to Monty Donaldson about these topics?
Well, I'm sure I have from time to time. I don't recall specifically, but I'm sure I did.
That's all I have.
Thank you.
Okay. I'm sorry for that interruption. All right, totally lost my train. All right, you said that you, have you seen a copy of that 2015 will?
I have.
The copy that we're referring to is the 2015 will.
Objection, that would get into hearsay, Your Honor.
Sorry, say again?
Objection, hearsay.
Can you explain a little bit?
If he's seen a copy of it, we're getting into hearsay, he's going to testify what's in that what he's calling.
The question is, have you seen a copy? I don't think the question calls for a hearsay answer, but we'll be careful about the next round of questions to see if it does call for hearsay, okay? All right.
And I just asked a question. Have you seen a copy of that 2015 one?
I have.
Okay. And the copy that you saw, did it appear to be signed by George, George Senior?
Now we're getting into hearsay objection.
That's not hearsay, overruled.
Yes, it was.
Okay, were there witnesses that signed it?
Yes,
Do you recall there was a notary or wasn't a notary on it?
there was a notary.
Okay. And the copy that you've looked at, was it a complete copy or was it missing pages?
You have the same objection, hearsay.
I also object that it's back on evidence.
I'm just asking his record.
This document is likely not going to be produced for evidence, is it?
Well, I'm going, I mean, I don't have to, I can if I need to, but I'm not asking about it at this point. I'm just asking the question if what his recollection was of seeing a copy of it.
Objection, hearsay.
The document is not in evidence. I am assuming you're saying that that's a best evidence problem.
I also anticipate objection to that as well, Your Honor, at this point, back on evidence.
Sustained.
All right, I'll move on. Did you, and I'm not asking what he said, did you talk with George at or around the time that he was in the hospital?
I did.
Okay. Did you know that he went to the hospital?
I did.
All right. And, do you know why he went to the hospital?
Yes.
Why did he go?
He had respiratory problems. I think it was related to COVID as I understood it.
Okay. Do you have any knowledge one way or the other, whether or not George Polydor Sr., at the time he was in the hospital, made plans to update his will and sign a new will in the hospital?
I do.
Okay. Did you talk to George when he was in the hospital?
I did.
Okay. How did you talk? When you spoke with him, how did you do that? Did you go and see him?
No, there was certain restrictions back then, and so there were telephone conversations we would have.
Okay, and the restrictions back then, again, just for the benefit of the jury, just for recollection, what were those restrictions?
With COVID, there was restrictions and masks and different people could come to the hospital, and so there was a number of restrictions.
Okay. How often did you speak with George when he was in the hospital?
Maybe a couple times a week, maybe once a week, we'd talk. Just either I'd call him or he'd call me.
Okay. When you talked with George, or when he called you, you called him, was there even an instance when he seemed confused to you on the phone?
Objection, or
Overruled.
Let me ask a question.
Sorry, I had to wait for the question to pop up for me a second.
Okay. So the question was, when you talked with George over that period of time, when he called you, or you called him, did he ever seem confused to you on the phone?
He did not seem confused to me, no.
Okay. Did he ever seem to lose his train of thought when he was talking to you on the phone during that period of time?
Not that I can recall, no.
Okay. Did he talk with you, he being George Sr., did he talk with you about what his plans were, his estate planning desires, his intent, his purpose, in having a new will or an updated will or a will changed at that time?
Many times,
Okay. And this was many times during the period of time he was in the hospital.
both when he was in the hospital and outside the
I'm
hospital.
talking specifically just about the hospital.
Yes,
Okay. And when he talked with you about those, did he reference his children?
he did,
Okay. Did he reference his wife?
he did.
Did he appear to know who his family was during the time when you're talking to him on the phone and he's in the hospital?
He did,
All right. Did he talk with you about his property?
yes,
Okay. Oh, he had businesses too. Did he talk with you about the businesses or?
he did.
Hearsay doesn't go to.
Overruled.
He did talk to me about the businesses, correct.
Okay. He seemed to understand the businesses he had and what needed to be done.
He did,
Okay. And again, this is just limited to the time that you're talking to him when he's in the hospital. Is that correct?
that's correct.
Okay. And then you said he talked about a will. When he was talking with you about the will, do you recall specific things he was telling you about what he wanted to do with his estate upon his death? Do you recall that?
I do,
Okay. Have you seen the 2022 will?
I have,
All right. Does the 2022 will align with what George was telling you about what he wanted to do with this property when he passed?
it does.
Okay. On occasion, let me ask, did you ever receive documents that Lisa forwarded to you while George was in the hospital.
I did, yes.
Okay. Tell me generally about that, and then we'll talk about that in a moment, but tell me generally, what was that? I mean, I said, send documents, receive documents, does that mean email, what is that? What happened?
Objection, compound, vague.
How did you receive those communications?
Sustain, can you rephrase and make it a little more simple? Thank you.
How did you receive those communications?
Electronically, via email.
Okay, and so, did you ever talk with Lisa about, hey, Lisa, what do you want to do with George's estate plan?
No, I didn't have conversations with Lisa about it. They were with George.
Okay. And then you did receive, you were asked for records, turn these records over, anything related to communications that you had with George or Lisa while George was in the hospital during this period of time. Is that correct?
Yes.
Objection leading.
Sustain.
Okay. You were subpoenaed?
Yes.
Okay. And that subpoena requested records that I'm sorry, what did that subpoena request?
Basically, records, and it was broad, just basically all communications, business transactions, basically everything. Yeah, George Polidorus.
Okay.
Senior.
Right. Did you turn over all those records?
I did.
Okay. And I'm asking about communications with George. Did you turn over records related to communications with George or Lisa during that period of time when George was in the hospital?
I did. Everything I had, I turned over.
Okay. I'm going to reference. Which exhibits? Okay.
There are two.
2A.
It's there.
Okay. I'm going to reference an exhibit, and I believe it's 2A.
There's like.
Right. I'm just gonna hand this. Make it easy.
Judge, this, client needs to run to the restroom real quick, would that be okay?
Yes. We're gonna continue though. Okay.
Well, we're ready.
Okay. All right.
Okay.
We'll continue. Are you calling this exhibit 2A?
Well, there.
Oh, okay. I'm sorry. You reminded me of the way on what we got, so these numbers are a little bit different. Now, can I ask a question about these documents, and then we can identify for the record later on for the.
Are these the business records that we talked about earlier?
Yes.
Yes, but maybe.
You want to approach it? Okay.
Call.
Let's just.
You may.
Yes.
Okay,
This is pretty good.
it's not pre-admitted. No, show it or not.
Mr. Thompson, have you seen this document before?
I have,
Okay, can you tell me? Let's see. Can you go through this and just tell generally for the jury to understand, what is this document?
it's documentation or basically changes to the will that George wanted to have incorporated as far as the will.
All right.
Objection, speculation. As to what George wants.
Yeah. I'll tell you what, I'm gonna sustain the objection, but you might want to ask the question just a slightly different way so
Yeah.
that you can
Okay.
rephrase the question.
Did you talk with George? You did, I'm sorry. Did you talk with George Polydorus about his estate planning and his desires and what he wanted to do with his property at the time of his death?
Yes,
Okay. And do you recall specifically what George wanted to do at his death, the changes you wanted to make to his will, as you sit here today?
I remember those, yes.
Okay. And if you look at this document, can you look at that and confirm for me whether or not this document that I gave to you references the changes that George wanted to have in his will?
Objection, back on that.
You want to offer this?
Yes, Your Honor, may I offer that? And because I'm just gonna call it exhibit A.
Mhm. Any objection?
No objection.
The exhibit A is admitted.
And for clarity, I'm
I've
sorry,
got one question.
Sorry, excuse me.
thank you for clarity, this is part of exhibit 1 on George Collier's. But so it may be helpful to call it 1A, so it's correspond.
I think that's a fair agreement. All 1A? Okay.
There you go.
Sounds good. Good discussion.
All right, have you seen the original of this?
I've seen so many different versions. I think when it came across electronically, I saw it, yes. So that's an original, that's what I saw.
Okay, are you smart? All right, who sent these actual, well, let me ask you, do you see, on each of these pages, can you, for the jury, because I don't have it in front of them right now, but can you, oh, there's right there. All right, so, is it on your screen?
It's in my hands, it's not my screen.
Okay, good, you got it all over. All right, good. At the bottom of each page, can you look and see, there looks to be some signatures there and a date. On the bottom of each of those pages, can you tell me what's the signature and what is the date?
George Polydorus, 2/1/22 on each of those pages that you'll see.
Okay, and then does there also appear to be some another handwriting there? Do you know what the other handwriting is? At the bottom.
I know George's signature is there, but I've got to confess, it could be Lisa's, but I just lost recollection now as far as whether or not that was Lisa's signature or not. I know it's George's and that's what I looked at, but I can't be honest with you as far as the other signature.
Okay, yes. How do you know, that that's George Polydorus Senior's signature?
Because I've seen it many, many, many times.
Okay. And do you recall how you received this information?
Electronically.
Okay. You know who emailed it to you?
My recollection, it was Lisa Polydorus that emailed this to me.
Okay. At the time that you received this document, Exhibit A1, I think is what we call it. At the time that you received it, did you have an understanding that it was Lisa who sent it? It wasn't George.
Well, I think it said on the cover sheet, if I'm not mistaken, At least it was sent from George's computer, at least that's my recollection.
Okay, and from what you recall, could you see if there was any intent from just the email? I don't have it right now, but the email that there was somehow some kind of deception that Lisa was saying, hey, this is George, or did she identify herself as, this is Lisa, I'm sending you this document from George's email?
That's the way it was presented to me and followed the conversation, so I understood that to be the case.
Okay. All right, have you had an opportunity to look at these changes in relation to the will that George signed, the 2022 will?
I have, yes.
Okay. This is exhibit 1, and I believe if you look down to your left, next to your feet, there's 2 notes. Okay, we're there. We're not very long.
No.
Okay.
Well, goodness. Are your monitors working down there? They are. Just double checking.
I know I put some notes here, but I'm walking these up. Okay.
Yes.
You see those logos on the bottom left, it magically appears.
See them now.
If you look at exhibit number 1.
Good.
Okay, and this document's been pre-admitted. Have you had an opportunity, or have you seen the will before, the one that's being offered for probate?
Yes, I have.
Okay. And after looking at exhibit number 1A, A1, and the will, is it clear, or can you tell, confirm for the jury that these changes that you said were George's were reflected in George's will?
Without holding up any further, I do believe that they're all in the will, so I can go through and more comment on it, but that's, I had looked at it before, and that's my recollection, and that's my testimony today.
Okay, all right, and just so for the benefit of the jury, because the jury's never seen this before, and I'd love to publish this at some point, we actually have the will. May we publish?
I believe it's in evidence, so you may publish.
Do you have a
Yes.
copy? We're going to give one version of the will to every person.
Okay, well, make sure, counsel, you review it and confirm that it's actually correct. Or that the document is the correct document that was admitted into evidence. I should say that a little bit more clearly.
Thank you. You want to? Oh, yeah.
I think it's on. No objection.
Thank you, Mr. Christopher.
No objection.
Thank you, Ms. Smith.
All right.
You may publish. I have a copy. Thank you.
Thank you. And real quick, before we continue, the changes that you saw, in exhibit A1, the changes in that exhibit, were those the same changes that you and George Polydor Senior discussed during the period of time he was in the hospital, and maybe during the period of time that he was discussing his estate planning desires with you even before you went into it?
Most of all these were discussed, yes. I don't know that today, the fact I can tell you specifically, if there was one that I can go through and tell you those that I remember specifically, so I'd say generally, yes.
Okay, I'm not gonna do that. There's one here where it says, if you'll look at the one, it might be the very first one that said, oh, Lisa Polydorus on the bottom right-hand side of DNP 016022.
Okay.
Okay. If you'll take a look at that one. Can you tell us, for the jury's benefit, can you tell us what it said?
Any and all assets.
Read the top.
Pardon?
Read the very word on the top.
Oh, Lisa Polydorus.
Okay, keep going.
Any and all assets not previously identified go to Lisa S. Polydorus involving but not limited to the following, and then it has the specific properties. There's 7 of the specific properties or assets that are going to go to Lisa Polydorus pursuant to this.
Okay, and when it says including but not limited, for the benefit of the jury, what does that mean?
It means includes those, but not everything else that is given to her.
Okay, what I want to do is just kind of walk through some of this quickly. If you'll take a look at, say, page 2 of the will. So page 2 of the will, there's a number 3 here. And I don't want to go line by line, but page 2 of the will, exhibit 1. And look at number 3. Just for the benefit of the jury and my benefit, can you please read what number 3 says, all the way A through B?
My daughters, Dorothea, Elena Polydorus, and Christy Polydorus Stovall, as tenants in common. Small A, the Ambassador Condominium Unit 208, located at 5050 Ambassador Way, Houston, Texas 77056. Note, a one-time payment of $14,000 is to be paid to my daughters by George Polydorus Company, Inc. for operation of the condominium until it is sold. And small B, a one-time payment of $25,000 to be paid to each daughter who survives me. You want me to go further?
No, that's good. I just really wanted to look at that, and I don't want to go page by page, but I just want the jury to see an example of the will that George signed, which was exhibit 1, and the pages that we were talking about earlier, which were what you characterized as George's instructions.
Right.
So if you will look at what you characterize as George's instructions and look at GNP 016027.
Okay, I'm there.
Okay, and so what I want you to do is and again, if you'll just read that for the jury so they can see that, see what it says, and just read that page through.
Dorothea and Christie convey Ambassador 50/50, 10,000 one-time payment from GP Co. Inc. to operate property till sold or otherwise. And the 10,000 scratch through and has 25,000 each one-time payment. And then there's George's signature, and then the date, February 1, 2022.
Okay, recall, help us remember, what was the date of the will? You have
February
every
9, if I'm not mistaken, I've looked at it before, I can tell you, I can look at it, but that's my recollection.
Okay, so,
Right, February 9, 2022.
okay, and then this was signed by George on February 1st, 2022.
Correct.
Okay. Can you confirm, and the jury can do this while we're looking at it as well, can you confirm that the page that you just read to us from George's, what you refer to as George's directions, match up with the will that George signed, just in this one particular instance?
It appears, yes.
Okay. All right. Would you like to go through and review every one of these pages? I'm just kidding. Everybody can look at that later on, so I'm not gonna walk through page by page on this will. All right. Did you attend George Senior's wedding?
Yes.
Okay. From what you could tell, did George seem to be excited that he was getting married to Lisa?
He was.
Okay. You were George's friend. Guys talk, right?
We do.
Did George talk with you about his relationship with Lisa?
He did.
Okay. How would you characterize the relationship between George and Lisa? George Senior and Lisa.
They were happy and George loved her and so I was happy that they were together and they had those feelings.
All right, I pass it.
You know, I was wondering, it's about 10 minutes till noon. How about we take a lunch break and then we'll come back and take the cross? Would that sound good to everybody? Okay. So we're going to take a lunch break now. And we'll probably be back a little bit, 12:30 if you can. We'll probably be back at 12:30. If not, maybe a little bit after that, and then we'll pick up with the cross examination. Okay, yeah. So remember, two things. One, keep an open mind. You haven't heard everything yet. Don't make any conclusions. If you feel like you're making a conclusion, stop yourself. Just make that open mind. Secondly, don't discuss anything that you've heard here, either with family, friends, partners, online, or even amongst yourselves, because it's not time to deliberate. Okay, do you have any questions for me before you go to lunch? No? All right, have a good lunch. We'll see you about 12:30-ish, okay?
All right, Gary.
Anything we need to do before we break for lunch? Maybe you're excused. Well, not excused perhaps, but you may step down.
Oh, I'm sorry. Dismissed for until you back.
Well, yes, you're all excused until about 12:30. Now, I've come to find out when I tell them 12:30, it'll be 12:45 when they're really ready, so. But try to be back here if you can about 12:30-ish. Now, they're going down to Luby's for lunch today, so if you're choosing to go down to Luby's, it may be a little awkward. I don't know how, if you're very familiar with the restaurants around here, but if you want to stay in the building, there's a place called Isabel's. It's a sandwich shop. It's underneath the juvenile court building, but you can get there in the tunnels very quick and come back. You're welcome to eat at Luby's. Just make sure that you keep that distance if you want to do that. Otherwise, you're welcome to walk around out there. The Treebeards is right, I mean, literally 5 minutes away by foot. If you want to do that, it's a great place to go. But all right, so we'll be back here. We'll try to be back about 12:30. You're a little bit late. I'm going to be okay with that. I'm going to be for that. We'll see you there.
So for the benefit of everybody, we're gonna call them on next. So we got our cuts, we have the video.
Okay.
So I just want to make sure that you guys have it.
Okay. So do you think we can go through there? Are there your objections to whatever they're going to do for crossing after we come back?
Yes.
Okay, that'll be fine.
Okay.
Okay, wonderful. Thank you.
All right. Thank you.
Thanks.
That's good.
I'm raising.
Oh. You don't want to.
That felt very fancy prison.
Being treated badly, being treated badly by Jessica, yes.
I was like, I mean, we're all going to do it and we're nice, you know. I was like,
I'll tell you.
well, I mean, like I said, but it was the perfect example, like, please don't hold this against any of us.
Yeah, no, I appreciate it in the way, and you cleared that up.
Yeah, no, I mean, we're all going to do it and we're all going to piss you
Yeah,
off.
that's right.
I handed you Dan, right?
Yeah. Show me what you have and then I need to eat.
And the problem is, the reason I'm saying is, I have it written out, but then I changed it, and I changed it like 3 times since yesterday.
Yeah, that's why, we did too. My error when I put the wrong thing down. That was supposed to be taken out.
Well, that's, I was like.
And yes, he would give me the character these.
Whatever, I mean, it's fine, I was like, I. One 6613 to 20, here, remember those sticking up here?
Yeah, I'm gonna just.
16613 to 25. You might need to put more in there. Hold on. 352. I'm sorry, I'm trying to look at it. 167 1 to 25 for that whole page. 168 1 to 11.
1 to 11.
Yes. I don't know what I did with the rest of it. Hold on. Trying to see if I can check this one here. I'm trying to figure out what I did. 160. Oh, what's that page? 169 14 through 25. 171 to 4 stopping at no.
171.
Before stopping at no. 171, I'm sorry.
170, line 1 to 4, stopping at no. Okay, I got it.
179, line 9 to 15. 171, 2 to 25,
2 to 20.
the first verse, and then 172, line 1. Yeah,
Okay.
it's cut off at a funny.
Yeah.
173, 1, 2, stopping at no. 174, 15 to 23, stopping at no. 4 to 23, stopping. Oh, yeah, no.
Yeah,
I did the 6.
I don't know, yeah.
Too late.
too late, yeah.
And he's like, I haven't seen you. Can I talk to you? No, I'm going to bed because I have to get a good body. And stuff. And he's like, I don't know why you do this. I'm like, right now, I don't.
I don't either.
My kids are like, well, we see you because I went home last night. Like, I went home and I'm just like, I'm gonna do this now.
I did too.
Because teachers here.
To a winter one. Yeah, but
Oh, by the way, you two can hear us over in.
Oh,
So.
thank you.
We love the
we love the public. All right, you wanna come get coffee with me? It's, here's this thing, how much?
Yeah.
Let me see. I can't get rid of all the other crap.
Yeah.
Because the WD's in the office. And I don't like all those tabs. So the more we go back on.
That's very
But-
beautiful.
Yes.
Yes. Wow. Start listening here. 039,698.
039,698, okay.
And this is an email from Lisa to Dan, June the 5th of 2022, and I don't see anything in here about the will.
Yeah, it is.
Let me see, I chose not to show email.
It's dated January 5th, 2022.
No, June 5th.
It's relating to his relationship with the children kind of throughout this.
Also, Your Honor, Dan Pappas' testimony was already discussed in the conversation after he got out of the hospital, that door was opened. That's communication that occurred after the door was opened.
That the door that was open was only as to the will. I mean, he said, the question was about the will, and that was the only.
I think one of your questions was to Mr. Pappas. You observed his relationship with his children, and what did you observe?
Yes.
Yes. And I think if that's going to be some kind of, I mean, that was broader than just the will. That was the whole question.
Yes, that was not limited.
Oh, right, and
This isn't June 5th. Okay, I mean, it seems totally irrelevant, but.
I'm having trouble locating.
Okay, it's 3.
Oh, thank you. I can do that. All right.
Sorry, we're also printing on the flyer.
Got it. Okay. June 5th, and this is many months after the signing of the will.
His judge, so the reason it's relevant is that Mr. Pappas testified, as you pointed out, not only to his conversations with the decedent after he had left the hospital, which was around May, but also to the relationship.
Okay. So if you have some kind of what? Okay. Yes, we can talk about it in just a minute. Okay, thank you. Let me keep this so I know who it is.
But part of Mr. Pappas' testimony was. And in recovery, it's a time situation, there's no rushing this, rest, physical therapy, good healthy food, lots of prayers, hope see him through this. So this really goes to his ongoing wellness afterwards, because I think there was reference to him remembering signing the will afterwards.
So at this point, I'm going to exclude this particular document, but I can see where this potentially could be introduced if you can lay a better foundation, because it is far in time away from the will. It's 4 months, give or take, away from the time that the will was created. So it's a little bit far in time. But my ruling is at this point is that I think it is irrelevant. But if more of the story develops, if we get closer in time to this and there's still discussion, then it may be urged. Okay. Okay. Is that it?
Yes, sir. No objection.
Okay, so everybody's clear on what's admissible and what's not, and so with those, the pages that you've all discussed withdrawn, there's no objection at this point.
Yes, sir, that's correct.
Okay, so it is admitted with the modifications that you discussed.
My clarification, what are we doing?
1B.
Are we doing 1B?
1A prime.
Oh, what? I don't care. I mean,
1A was the notes.
You're, okay, so 1B.
1B, okay, we'll call it 1B.
So 1A is an evidence and this is 1B, it's an evidence.
Right.
It's an evidence.
Okay, so this is 1B, but on George's, so admitted with modification.
Yeah.
I wrote because I was right next to it.
There's this one, did that?
Oh, yeah.
GMP, this is Lisa's one, this is GMP 1A, and then.
Okay, so I have a no. Hang on just a second. I have a note from juror number 12, Virgilio Ruiz. Virgilio Ruiz says, I have a mental condition, bipolar disorder. I feel 100% now, but would like to speak with the judge. Now, I'm not going to speak with a juror outside the presence of the attorneys in the room. So if is it Mr. Ruiz? If Mr. Ruiz would like to speak with me here in front of the attorneys, I can do that, but I can't really talk to him outside of it. And so if you want to bring him in, okay?
Judge, can I ask a quick question?
Mhm.
If nobody objects, me talk to him on the record, and we can always look at it later on, like you did with Mr. Donaldson.
If you would like me to do it in chambers and you all agree to that, okay, so
Let's step out.
okay, but why don't y'all just step out, so because that way she doesn't have to get another machine and set it up.
Yeah.
Okay, so, yeah, tell them, come on, over here. I'll talk.
Yeah, go ahead.
Go down there again. I was like, how we never sound to at lunch, but then
Did anybody get to eat? No, you have lunch? A little bit? Okay, it's important. Oh, you have some coffee? Okay, good. Caffeine, good. Let's see, Mr. Pappas, you were on the stand, and so why don't we go ahead and have you take the stand, and I'll just remind you before the record that you're still under oath. Okay.
I was kind of.
I understand.
Okay.
Yes, sir, it is. Thank you.
Also, the hinterland here is, do you have a problem if I get a move?
Not at all. Not at all.
I tell you, I get dizzy, I may pass out, you still sit down or. Yeah.
All right, for the jury.
Thank you. You may all be seated. Hey, Mr. Christopher, I believe we left off. You were going to begin cross?
Correct, see.
Yes, sir.
Mr. Pappas, and Christopher, good afternoon.
Good to see you.
I represent George. I'd like to draw your attention to exhibit 1A. Talk about that with Mr. Cook a little bit. And Mr. Cook, a couple of his questions said that this exhibit 1A were instructions or directions from George in his question. Do you remember that?
I do.
Did you say that those were George's instructions or direction?
Well, through Lacey, yes.
Through what?
Through Lacey sent those to me, but George signed.
Okay, but did you say that this exhibit 1A, which is the handwriting on there, did you say those were George's instructions? Direction?
Yes.
Okay, whose handwriting is this on exhibit 1A? First page.
I don't recognize the handwriting, I just see George's signature.
You don't think, you're not saying that that's George's handwriting, are you?
I'm not saying that, I'm just saying that was, I know the way George operates and that's what he approved.
That purports to be his signature on 1A, correct?
Correct. And then there's some modifications, the initial of those modifications.
Right. And also, are you saying that the same person who signed this, George, is the same person who wrote these notes that appear to be pretty good handwriting? Are you saying that's George's handwriting?
I'm not saying that, no.
Okay. Do you think it's Lisa's handwriting?
I can't honestly tell you, just like that down below, I can't tell you that.
Okay, and you can't because Lisa didn't tell you. I wrote this down and included this in an email and sent it to you. She never said that to you, did she?
No, but I also put in context of what I had with the conversation.
Do you think that it's handwriting? Let's be real clear. If I'm looking at page 1, there's also page 2, page 3, page 4, page 5, page 6. All of those have that kind of nice, neat handwriting, correct?
They did, yes.
That, you know, that's not George's handwriting when he was in the ICU, correct?
I don't believe that's George's, no, I've seen his handwriting in his printing, so I would agree with you.
Fair enough. And then I was wondering, this is a series, a sequence of documents that we got from your office, you and Monty's office, correct? You're in Monty's office, correct? Okay, and you and Monty worked together, is that correct?
That's correct.
And, if Monty earns a fee, say, on this estate planning that he did for George, and perhaps Lisa, if she's sending information, does that fee run through your firm, or does it go just directly to Monty?
We operated so long, and I let him have all the autonomy he wants, and so the long story short is, I don't know.
You don't know if funds run through your firm or just through his?
I don't know, but he makes the arrangements, and he tells the office manager, and for 40 some odd years, it's worked, so I.
Okay. And I think you testified in your deposition, and maybe on direct, you're not an estate planning lawyer.
I'm not.
You don't do that sort of. What I'm gonna show you, I'm gonna mark this, would be C, exhibit C. I'm gonna add. What do you want? About 1B, I'll mark it 1B.
One B is already, 1C would be next in line.
Okay, 1C it is,
Yes.
I'm gonna mark it as 1C. And. Now, if you look at this packet, that I think you testified, you did testify to Mr. Cook's questions, that this packet was transmitted to you by Lisa, correct?
Yes.
She said that to you, correct, in the transmittal, right?
That or George told me, I knew it came from Lisa.
Okay, and I guess the question is, do you see exhibit 1C?
Yes.
And I think in the sequence that we got from your law firm, if you look at the page numbers, this number would be the first page in what Mr. Cook offered as 1A, correct?
And then there's my memo to Monty down below that.
We'll get there, but I wanted to establish the sequence. We've got a base number, page number 33608, correct?
Yes.
Okay. And this one on the very next, which is the first page, what Mr. Cook was questioning you about, is 33609, correct?
Yes.
So this, at least the way it was kept at your firm, should go right there in front of 33609, correct?
It appears that way. Again, I don't know about the note, I gave Monty a note.
Okay, is that your handwriting?
That's my.
I'm not being critical because mine's work, but that is your handwriting on that page, correct?
It is.
Okay, and does this refresh your memory at all as to how the documents that Mr. Cook was questioning you about, that were George's instructions, George's directions, how that came to you?
Yeah, just like you said, it came off Lisa sent it, and George's instructions, yes.
Okay, well, the email says from Lisa, the things I wrote today for the will, attached are the things I wrote today for the will, correct?
Right.
That's Lisa talking, correct?
Yes.
Okay, and then come to find out, you don't know whose handwriting this is. That's the substance of this exhibit 1C and 1A, but you know it's not George's, probably Lisa's, right?
No, one that I know for sure is George's signatures on each of those.
Okay, when you said no, you weren't disagreeing. This handwriting that has the substance, that's not George's, correct?
I agree.
Okay. And we'll wait and see if that's Lisa's. I've got another question. The backside of this document. You get the backside of this. Now, Mr. Pappas, at the time that you received this, and I think the date of the email is February 1st, 2022, correct?
I think, you know, it's what it is. Yes.
Okay. And I think you remember when your deposition was taken, when the lawyers got together and sat in a room, and there was a court reporter and swear an oath, tell the truth. You remember doing that, correct?
I remember doing that, yes.
And does April 22nd, 2024 sound right?
If you tell me that's the date, then I'll accept that.
Okay, yeah, I understand. Would it be correct to say that you were on the periphery of the estate planning for George Polidorus?
You can say it that way. I told you what happened. You know, I'd get instructions and phone calls, and if that's the periphery, then I've been forward those to Monty, and so that's what my role was.
Well, it's not really my word. I mean,
We used the word periphery. And
yes, and didn't you use that word in your deposition?
I may have, if that's what I said.
Judge, may I just approach the witness?
You may. Would you mind checking if your microphone is on there?
I'll turn it on, Judge.
That's all right. Thank you. It might be easier for the jury here as well.
The question is, did you state under oath that you were on the periphery of the estate planning? What I'm going to let you do is let you read this, just for read whatever you want to for context. You don't need to read it out loud with the jury, and then I'll ask you a question.
Just real quick objection, I mean, he already said that if that's periphery, that's what you're using, it just seems like improper impeachment. I don't quite understand it.
He's not impeaching right now.
Oh.
It sounds like he's refreshing.
Oh,
That's one of the descriptive words I use. I explained what I was doing, and then I used that word.
Okay, after having an opportunity to look at your deposition under oath, you remember now, and I understand we forget things that happened a year or so ago. You used the word periphery to describe your role, correct? In the estate plan.
Yes.
Okay. Whatever, I mean, it's your work, it's in here, it's under oath.
But I explained to you what, in detail, as you can see, what I did, and then we called it, that's on the periphery.
But you've been a lawyer for how many years?
Over 50.
Okay, and you've taken depositions before.
I have.
You know what it's like to be under oath.
I do.
You know what it's like to be under oath at trial, correct?
I do.
Okay. And tell the jury, you used the word periphery when you were asked, were you involved in estate planning for George? You said on the periphery, correct?
That's part of the description, yes.
Right, and there's more.
Yes, there is.
But when you summarized it, described your nature and the role, you said periphery.
One of the words I used, yes, Counsel.
Not my word, it's your word.
That's one of the words I used, yes.
Let's talk a little bit. You mentioned with Mr. Cook that you communicated with George Polidorus while he was in the hospital, correct?
Yes.
That wasn't really an easy conversation to have with him, was it?
He was having shortness of breath, so to that extent, it affected his ability to, talk.
Okay. And it was a pretty serious problem, wasn't it? I mean, based on what you could tell, it sounded like it was a serious problem, correct?
He was in the hospital for it, so that was serious enough to be in the hospital.
Okay, and frankly, it wasn't just the hospital. He was in the ICU on February the 1st, correct?
Yes.
And he was in the ICU of the hospital for COVID, correct?
That's my understanding, yes.
Do you know anything about any of the diagnoses, any of the medical problems that he suffered from while he was in that hospital and when he was talking to you?
I don't know the medical diagnosis, no.
Okay, but you were able to hear over the phone that, in your opinion, his lungs didn't seem to have the capacity to communicate, correct?
When he communicated, it was hard for him to communicate because he was short of breath.
Didn't you say, do you ever remember thinking and testifying that he didn't have the capacity to communicate because of his lungs?
I don't remember that.
Okay, may I approach that?
You may.
Same routine, you probably, you've been on the other side of this, right?
Okay.
You know how it looks.
Sure.
I don't know which is worse, being my side or your
Who's
side.
taking this side of our?
That's sustained. That's.
So here's what I'm looking at, and again, feel free to look at the transcript and.
That's what I said. Didn't have the capacity, he was short of breath. But we'd have conversations like that.
Right, but you kind of skipped over the part that I was trying to get. It was hard for him because his lungs, he just didn't have the capacity to communicate. Did I read that right?
Well, part of it, yes.
No, tell me what I got wrong with that sentence.
Well, and I said, a lot of times he sounded short of breath, we'd have conversations like that.
Right, with someone where it was hard for him to communicate because of his lung. He didn't have the capacity to communicate. Those are your words, right? Yes.
Some of the words, yes.
No, but are these your words? He didn't have the capacity to communicate.
I said that, but the evidence, yes.
And would it be correct to say that George, you talked about what George's wishes were. George was concerned about Nikki having a place, correct?
Yes,
Okay. You weren't present when the will was signed.
I was not.
You don't know what date it was that you spoke with George in February of 2022, correct?
I don't.
And you don't know when he went into the hospital, correct?
That's correct.
And you really didn't know, and I think you testified to this, you really didn't know George's condition. He just basically, he couldn't breathe. He had a hard time breathing, correct?
That's what I know, yes.
Yeah, based on what you could tell talking to him over the phone.
Right.
And there are limitations to what you can determine about somebody's condition when you're talking to them over the phone.
That's the limitations that I'm aware of, yes, sir.
Right. Your Honor, I'll pass the witness.
All right, Ms. Smith, do you have questions?
I do, Your Honor. Mr.
Mhm.
Pappas, can you hear me okay?
I can hear you fine.
Okay, good. Can everyone over there, I don't want to address the jury directly, Your Honor, but can I just make sure the jury can hear me okay?
Of course.
Okay,
Are you able to hear everyone?
okay.
good.
My microphone's just kind of far away.
You can scooch it up to you if you want.
Mr. Pappas, my name is Laurel Smith. We met at your deposition. Do you remember that?
I do.
And I represent Christy Stovall and Dorothea Polydoros. Do you remember that?
I remember that too.
Okay. And you testified earlier that you started your own law firm in 1986, correct?
Correct.
And George Polidoro was a client of yours before you started your own firm and then became a client of yours at your new firm, right?
Yes,
So you've known George for at least 4 years.
yes,
And then you consistently represented him after that.
correct.
And when your representation typically centered around commercial real estate dealings and some litigation, is that fair?
That's kind of the bulk of it as far as what I did for George. I mean, there were other things after all those years, but that's the main business that I conducted for George on a professional basis.
Okay, thank you. And you previously testified that George had an engineering degree, is that right?
Yes,
And you've described him before as being analytical.
yes,
He was engaging
very much.
and he had a strong personality, is what you said.
I think that's right.
Okay. And it would be fair to say that George was successful in his business practices.
Yes,
Okay. And you've addressed this, I think, already, but just to confirm, you are not an estate planning lawyer, right?
yes,
You did not render any services, any legal services for estate planning to George Polydoros, correct?
no,
And it's not part of your law practice to typically render estate planning services to others, with that.
that's fair.
And when you would get an estate planning client come into your office, would you typically refer them to Monty Donaldson?
The majority, yes,
Okay. And turning to the time period that really surrounds the execution of the 2022 will, Isn't it true that Lisa emailed you at least twice regarding George's stay in the hospital?
I remember the one that we've just discussed.
Okay, may I show you that email?
That's one February one I have.
Okay. I'll show you. An email dated January 13th of 2022, and it'll take just a second for it to load on your screen. Do you see it right there in front of you?
Not yet.
Okay. Do you see it there?
I do now, yes.
And isn't it true that on January 13th, 2022, Lisa Polidoro emailed you with a subject title, George in hospital?
Yes.
Okay. And you now recall receiving this email?
Well, I must have, I see my handwriting below, so I know I received it.
Your Honor, I would offer this as proponents. Actually, if I could offer it as Exhibit 1D, it's all part of the same tranche of documents.
When D, okay, all right, is there any objection?
Yes, sir.
No? When D is admitted.
Thank you.
Mhm.
And may I publish it to the jury?
You may.
And in this email, Lisa lets you know that George is in the hospital. Is that fair?
Yes,
And she tells you that he has severe COVID.
correct.
And isn't it true that Lisa emails you again regarding George's condition on January 24th of 2022?
I don't remember, but if you have, I'll be glad to look at it.
Sure. Give me just one moment. And if you don't mind just letting me know when you see it pop up there on your screen.
I think it's all clear right now.
Oh, it is?
Yeah.
Oh. I'm learning as I go, Judge.
You hit them all right there. Okay, it'll pop up in a second.
You see it there in front of you?
I do now, yes.
Wonderful. And in this email on January 24th of 2022, Lisa informs you that George is now in the intensive care unit. Is that fair?
Yes,
ICU for short.
right.
She also states in this email that George's condition has not changed much, only with slight improvements in his lungs. Is that right?
That's what it says.
And then she tells you that they transferred George to the ICU because he was getting agitated at night and taking his oxygen mask off. Is that true?
Yes,
And you testified today already for the jury that you were communicating with George in 2020 and in 2022 when George was in the hospital, correct?
yes.
But you said that you, Judge, I'm sorry, I don't know if I pressed the wrong button.
You press the wrong button?
I
Maybe.
tried to press publish, but,
Okay, so you'd be table 1, publish? You want to publish?
yeah, I'll just clear it for now. I just wasn't sure what button I pressed to get it. Our faces all on that screen. I want to avoid doing that again. So you were talking to George in 2022 when he was in the hospital, correct?
Yes,
You also testified you didn't visit him in the hospital.
that's correct.
So you never saw him in person during that period of time from January through until May when he was in the hospital.
I didn't see when he was in the hospital, correct?
Okay. And you also told the jury earlier that you mainly spoke to George over the phone.
Yes,
Isn't it true that you don't actually recall any specific dates that you talked to George?
I didn't record it, so I don't, and it's 3 years, so I can't tell you specific dates.
Okay, and I recall you telling Mr. Cook earlier that you had these detailed phone conversations with George while he was in the hospital about his estate planning. Do you remember that testimony?
Right, I basically talked, when George had these things, he'd transmit to Monty and I'd send Monty those notes, so I remember that as far as the estate planning.
Objection non-responsive to everything after, yes. Isn't it true that you have previously testified that you would talk to George on the phone while he was in the hospital and he would have difficulty breathing?
Yes,
Okay. And those conversations were not very long, correct?
they were not long.
They were, I believe you testified not longer than 10 minutes,
That's correct.
okay? And so what you're telling the jury today is that in these short phone calls where he is having difficulty breathing, that you're supposedly having these detailed estate planning conversations with George during that time? Is that your testimony?
I'm having conversations about estate planning on how detailed they are, but he'd give me specifics like what you see in that email.
But you don't recall specifically the content of those individual 10 minutes or less conversations, correct?
Probably the one that I do remember is the one that one February 1, where he itemized everything.
You recall a phone conversation with him on February 1?
Well, I remember the phone call and then the email that Lisa sent me that memorialized what we had said.
Okay, we'll get to that in just a minute. Isn't it true that George had difficulty hearing?
If he didn't have his hearing aids in, yes.
Were you present during these phone calls to see if he had his hearing aids in?
I couldn't see what he was doing at the other end.
Okay, and you've also previously described him as weak when you spoke to him, is that true?
He was weak at times, yes.
Okay, so fair to say he did not sound like the usual strong George that you knew?
From time to time he did, that's right.
Isn't it true that there is a significant difference between how George sounded before the hospital stay to the phone conversations you had in the hospital?
There were some changes, yes.
Okay, and when George was in the hospital, isn't it true that Lisa would pick up the phone when you would call?
Sometimes he would, yes.
Okay. And you've previously testified in your deposition, you did not remember talking to her about George's estate. Is that true?
That sounds right, yes.
And I believe you also had said that Lisa wasn't very interested in George's estate plan.
I think that's right.
Isn't it true that on February 1st of 2022, Lisa Polidoros called your law firm to talk about changes to George's will?
All I remember is that email.
Okay. Let's look at exhibit. Do you have a copy of exhibit 1B in front of you, sir? If not, I can provide you my copy.
1A and 1C.
You may.
Recommend handing the witness exhibit 1B. Before I move on, may I offer the January 24th, 2022 email that is currently up on the screen?
Good. No objection, that was fine, we saw it.
Okay, and just for clarification, is this all in one that was already previously?
No, sir.
Oh, this is
This is-
separate. Okay, all right. Well, since there's no objection, 1D is.
Yes. Mr. Pappas, if you will turn with me to. And I'm going to direct you to the base number at the bottom left corner of the pages. And we're going to flip to what should be the second page in that stack. And you should see a number GNP 039753, and let me know when you can see that.
Yes, I see that.
Okay. And isn't it true that this is a note from your answering service from Lisa Polidoros?
That or maybe, no, that would, I see it 10:40 a.m., so it would have been from the secretary. Apparently I wasn't there to receive the phone call, so this was a message from the receptionist to me at 10:40 a.m. on February 1.
Okay, but fair to say that this is someone at your firm that answered this phone call and wrote this note?
Yes, that's fair.
Okay, and so what this note says is that Lisa Coladoros has info and wants to make sure that you have what is needed. Is that true?
That's what it says.
And again, that's on 10:40 a.m. on February 1st of 2022.
Correct.
And then, isn't it true that there is another note that in your business file, that Lisa will get information and then get the rest? I'm sorry, that Lisa will get information and then get you more information for the will?
Are you talking about GMP 39751?
Yes, and that was a terrible question, so I apologize.
No, that's all right. I just want to make sure I'm with you on this.
Yes,
It says she will get info, let me get back, and I put my initials, do not commingle funds, and all the rest goes to Lisa. So that's a message from the service. Couldn't discern apparently the name, but yes, that's what 039751 says.
okay, and I'm gonna, just so that everyone's on the same page, I'm gonna put up in front of you on your computer what we're all looking at. Which has been already admitted as part of Exhibit 1B. And this is the note you were just talking about, correct?
Right.
And this one also says message from answering service. And then it says, has Lisa, do you see that?
I do.
Her name? And then is that her phone number?
It is.
Okay, and doesn't it say she will get, I think it's a short moniker for information?
And then get with, and then like I said, my initials, Daniel C. Pappas.
Okay. And then isn't it true that it says, do not mingle funds at, we don't know what it says, right?
Do not commingle funds at, and then apparently I didn't write down the rest, but, and then just at least as followers, all the rest. So
Okay.
it's both of my cryptic notes.
Okay, and you identified that last line, it says Lisa S. Polidoro and an arrow, all the rest, right?
Correct. Yes.
Okay. So Lisa's now called, there's at least been 2 phone calls to your office on February 1st of 2022, is that fair?
I'm not sure when this last one was, but the first two, well, the first one is George's message to me. That's page 1. Page 2 is Lisa's message to me. And the third one, I'm not sure. I didn't date it.
Well, let's go back to that first message, what we
Okay.
talked about a minute ago.
Right.
It says Lisa Polidoros's name and phone number, isn't that true, on GNP 39753?
But that's not the first page. I said the first page was the one where George called me.
Okay, I'm referring to this page, the one that's up on your screen right now.
Okay. Yeah, that's the one you spoke about before where I spoke with Lisa. Yes.
Right, so you talked to Lisa first, she left this message at your firm on February 1st.
Yes.
Okay, and then when we're talking about this next message, this was your notes from a phone call, correct?
Right. And I don't know that Lisa called, but that was my note. So I would know how to get back with Lisa. So I'm not sure if she called or I assume she called, but I don't know that for a fact.
Okay. So, but then also on February 1st, Lisa emails you with handwritten changes to George's will. Is that true?
Yes, that's what we're talking about over here.
And she sent those to you, not to Monty, is that right?
She sent that to me. That's correct.
Okay. And this is, I'm putting up the email we referred to earlier. It's also part of Exhibit 1B. If you'll flip one page, it's also up on your screen.
Yeah, that's the same one. That's 1C.
Yes, I think 1C is a portion of 1B that was previously admitted. And in your deposition, isn't it true you testified you didn't recall receiving this email?
If that's what I said, I don't remember today. I do remember George's call, and I remember, matter of fact, it's verified by the handwritten note that you'll see.
Objection non-responsive as to everything after it, that's what I said.
Sustained.
And this email shows that from Lisa to you regarding changes to George's will shows that you had at least some involvement in George's estate planning. Is that true?
Only the extent of passing this on to Monty.
Okay. And then attached to this email, isn't it true that these are the handwritten notes that you've talked with Mr. Cook and Mr. Christopher about earlier? This is the first page. I can go through all of them, but this is the attachment to that email we were talking about a moment ago.
Yes,
Okay. And to be clear, the handwriting, I'm not talking about George's signature at the bottom, but the rest of the handwriting is not George's, correct?
right, that's what I said earlier.
Yeah, you know what George's handwriting looks like because you were his legal representation for many years.
Right, I've seen notes from George, yes.
Okay. And, to confirm, you did not participate in the drafting of the will, is that true?
That's correct.
You only took these notes and passed them along to Monty?
That's basically right.
Okay. Isn't it true that in your file that you produced to us from your firm, there's another note on February 8th, 2022 from a phone? That you-
And I don't remember it now, but you tell me that.
I'm gonna put it up on your screen, and this is again part of Exhibit 1B.
Okay, I see it now.
Is this your handwriting on this note?
It is.
And there are several comments on changes to the will, is that fair?
Well, if I can rate it,
Is it true, it says call GMP, Hospital Methodist, and then RM.
oh, I'm on a different page.
Okay.
I'm sorry.
It's okay, the correct one, to match it up is the one on your screen. You might have to flip a few pages in.
Okay. That's the same one that files, yeah, isn't that the same one? Oh, I see, that has a sticky note. It's the same as the next one without the sticky note, right?
As long as it looks like the one that's up on your screen in front of you.
Okay.
It's a handwritten note dated 2/8/22. And I can blow this up for you a little bit if you,
I'm sorry.
is that better?
Okay, now I get it.
And is that your handwriting that says, I think it says want, I don't know what that word is, and then.
Went over the will.
And over the will, okay. And it says not a lot of changes, correct?
Right.
And doesn't it say that Christie is assigned the account at Prosperity for Nikki's benefit?
Oh.
Okay, sure.
Can I get an answer to my pending question?
Why don't you, yeah, go ahead and answer the question.
Okay.
Great.
Run it by me again, I'm sorry.
If you look in sort of the middle right portion of this note, isn't it true that it says, Christie is gonna be assigned the account at Prosperity Bank for proceeds from the sale of 2829 Timmons Unit 208?
Christie assigned account at Prosperity Bank and proceeds from sale. That's on Nikki's unit, yes.
Okay.
That's when I found out that Nikki, it was sold and she was gonna be the trustee or custodian for his money, yes.
Okay. And with that, we can take a break, Your Honor.
All right, thank you. Let's go ahead and take a 10-minute break, come back at 2 o'clock. Mr. Pappas, you are not to discuss anything with your attorney during the break because you're still on the stand, okay? And you both understand that.
You're right.
I'm not his attorney.
I'm sorry, the,
No.
the attorney who called you as
Yeah.
a witness or any of the other.
That's okay.
Sorry, thank you for that clarification. You kind of knew what I meant. All right, so we'll go ahead and excuse the jury for 10 minutes and we'll come back at 2 o'clock. We can possibly make it back at 2 o'clock.
All right, so jury,
Maybe I need a break too. I don't know if y'all, I don't mean this to sound. Anyway, I'm not, I have a little thing from Judge Randy Wilson on how I use depositions in trial court. And I see a lot of times that there are disparate ways of people or disparate understandings of how, and I know judges have it. Not saying anybody's wrong or whatever. Here's just a little thing from Judge Wilson. This is how I do depositions, particularly when you want to use a deposition for impeachment, just so that we're all on the same page of how it's going to run here. And it probably doesn't go to everybody else, but if you want this, you're welcome to it. I'm not trying to be preachy or anything, just trying to get everybody on the same page about how we're going to use depositions in this trial, okay?
Yes, sir.
Right. All right, have a good break. Oh, let me turn this off. Okay.
All rise for the jury.
You did it. Mr. Bennett, I think we left off with you. You're going to continue your cross-examination. All right.
Your Honor, I'm going to show again that note we were talking about previously before the break. That's part
Very
of
good.
exhibit 1B. Mr. Pappas, do you see that note there on your screen? And it also should be in your exhibit in front of you.
I did, yes.
Okay. And in this note, it doesn't specify who you're talking to when you're writing this note. Is that correct?
From that note, I'm assuming it's George because it says call George, GNP, George Nick Paul Norris. And then I can see what I discussed with him based on that.
Objection non-responsive.
Sustained.
This note doesn't specifically state who you're talking to at the time that you're writing this note. Is that correct?
Is what I see there, yes.
Okay. And you testified a few minutes ago that you don't recall any specific conversations that you had with George on any particular date. Is that true?
Except this refreshes my memory.
Objection non-responsive.
Sustained.
Isn't it true that you have testified previously that you don't recall any particular date on which any particular conversation with George Polidoro?
No, I apparently don't have any specific date other than just to look at this.
Okay. And right before the break, we were talking about the portion of this note that pertains to, and I will blow it up for you, Christy being assigned the account at Prosperity Bank for the proceeds from the sale of the Timmons property. Do you see that on the note?
Yes,
And you're familiar with the account at Prosperity that held those sales proceeds from the Timmons property. Is that true?
I'm aware that there was a bank account at Prosperity for the proceeds from the sale of the property.
Okay. And looking below that portion of the note, does it say Christy is a signatory for account bank? Can you see that portion?
Christie is the account on that. It's a signatory on that account. And then I put the amount that was in the account.
And what is that amount there?
It's like 128,000 in account.
Okay. So 128 or 120, somewhere thereabouts.
Right. My right is not very good.
That's okay, mine isn't either. Your Honor, may I get approached with an exhibit? This one is unfortunately going to be paper.
You may. Mhm. Thank you.
Mr. Pappas, I'm showing you what has been previously marked as Dorothea Polidoros and Christy Stovall's Exhibit 9. And if you'll turn with me in that exhibit binder to page 209, it should be a Bates label at the bottom.
Good.
Do you see there a Prosperity Bank statement dated February 28th of 2022?
Yes,
And that's for account ending 6899?
yes,
And at the top is this account held in the name of George Polidoros, Christy Stovall, and in parentheses it says NGP's account.
yes.
And do you know what NGP stands for?
I just assume it's Nikki's initials.
Okay. Your Honor, I would move to admit exhibit 9, CSDP exhibit 9, page 209. Can admit it as exhibit
Page
9A.
209.
There.
Any objections?
No.
Exhibit 9, page 209 is admitted.
Thank you.
Mhm.
And may I have copies of the jury?
You may.
See that the balance on that account in February, as of the end of February of 2022, was $39,546.93.
Yes,
And there really aren't very many transactions on this one statement, are there?
no, zero deposits, zero checks.
Okay. So there's not really a lot of activity, fair to say, in the month of February of 2022.
That's correct.
And February of 2022 is when George Polidoros is in the hospital, correct?
Yes,
It's the same month he executes his will,
correct.
and also the same month that you talked to him about this Timmons account. Is that true?
I say that, and I see the 2 accounts at Moody's, so I'm not sure. I bracketed it off. Ricky is a signatory in that account. And then I've got 2 accounts at Moody's, so I can't tell you which the 1, it's like 120 some odd thousand belong.
Okay, do you need to see the accounts from Moody to see if those have $120,000 in them?
It's gonna be one of those 3 accounts, because there's 2 accounts at Moody, apparently my notes, and then 1 account at Prosperity.
So it's your testimony that one of the Moody accounts or the Prosperity account has $120,000 based on your notes?
That what my notes appear to be, so.
Objection, I think it's a mistake. I think you said 2 accounts and 1 account.
Right.
Okay, that sounds like their clarification has been made. Okay.
Deal with more binders.
Okay.
And if you'll give me just a moment to get it on my computer. You see the document in front of you on your screen?
Not yet. I do.
Okay,
Yes.
great. And do you see, I'm showing you what is a statement dated February 15th of 2022 in the name of Nick George Polidoros. Do you see that?
I do.
And it says George Nick Polidoros, rep payee. Is that the decedent that we've been talking about?
I assume that's George's senior, yes.
Okay. And if we scroll down on this statement, do you see that there are 2 account numbers here for account 1037 and account 1284?
Yes.
And Your Honor, I would move to offer this as exhibit 14A.
Any objections?
No, no, sir.
14A is admitted.
And if we look at the balances of these accounts, it shows.
Okay.
we're looking at accounts 1037 and 24 on this statement. Do you see both of those accounts listed here?
I do.
And so for the month of February of 2022, is it true that account 1037 has a balance of $1,077.47?
Like 1,077.47.
Okay. And account 1284 has $119.13?
Yes,
Okay. So of the prosperity account that we referenced a moment ago, and these two Moody accounts, none of them have a balance anywhere close to $128,000.
no, it doesn't appear.
Okay, so the handwritten note that when you were on the phone with whomever you were talking to has an incorrect amount of the funds on deposit for the sale of Timmons. Is that true?
Not $120,000, no.
True. So doesn't that mean that either Lisa's giving you the wrong information on the phone, if you're talking to Lisa, or if you're talking to George, George doesn't know the balance of his own accounts? Would that be fair?
Whoever gave me the information didn't give me amounts that square up with those statements. I agree with you.
Thank you. And isn't it true, also on February 8th, when you took that phone call, there was an additional email sent to Monty with additional changes to the will? And that should be in your exhibit 1B.
Was that the one where they had the note discharged?
No, sir, I will direct you to it in just a moment. So we're looking at, it is after those handwritten notes, right afterwards, it's GNP 33594.
Right, and then with the attached.
I'm just asking about this one.
Okay, the first page is, yes, George asked me to forward this document for your review.
Okay, so GNP, and this is part of exhibit 1B again, just for the record.
Yes.
And that's it, previously been admitted into evidence. Wait for it to pop up there on your screen. And this is an email that was sent from Lisa to Monty Donaldson the day before the will was signed, correct?
That's what it appears to be, yes.
Okay. And it lists additional changes to the will, correct?
Corrections as follows, yes.
Okay. And what does it say there that if the will is null and void?
To watch change to if my wife predeceases me, this will is null and void. And then there's a handwritten portion.
And can you read that handwritten portion?
No, this means you die intestate, estate divided. I think it's intestate, maybe. I can't read the very last word.
So is it fair to say that this states if the will is not effective, then George would have died intestate?
If the will was not, he would have died intestate, yes.
Okay. Are you familiar with the laws of intestacy? And I'm not asking you what they say, I'm just asking if you're familiar.
Generally, yes.
Is it fair to say that under the laws of intestacy, a spouse and children will both inherit?
Yes, yes.
Okay.
What do I know?
Understood. And you were not present for the will execution ceremony, correct?
No.
Okay. And before that will was executed, I think there was one other email that was sent, and this is just to tie up the bank accounts that we were referencing earlier, and it's also part of exhibit 1B. And it's this February 8th, 2022 email with one more correction to Monty. Do you see that on your screen?
Yes, the account number for Prosperity Bank Tim's account, and it gives you the account number.
Okay, and that 6899 account is the Prosperity account we looked at a moment ago, true?
If that's the number, I don't remember the number, but if you tell me it is, I'll take your word for it.
I'll represent to you that it is.
Okay.
And this shows that it was, this email was coming from George Polidoro's email at 4:12 PM. Is that true?
Yes.
Okay, but you don't actually know who typed this email,
I
correct?
do not.
Isn't it possible it could have been Lisa Polidoro's?
I don't know.
Okay, isn't it true Lisa had access to George's email account?
You had some, yes, and we saw some emails, so,
Because she had emailed you previously from his email account, right?
yeah, I think we saw two.
Okay. Moving on to the execution of the will, and you testified that you weren't present for that execution. Isn't it true you've said that George never seemed confused to you?
That's correct.
Okay, and you have also testified that from your understanding, a chaplain and George's favorite nurse came in to witness the will execution.
That's what I was told. I wasn't there, but that's what I was told.
Okay, isn't it true that that supposed nurse was actually an administrative assistant or a unit secretary for the hospital?
I was told she was a nurse. I don't know if she was different than that.
And you were told that by George?
I think from Monty.
Monty was the one that told you?
I think so. I think he told me that it was his favorite nurse and the chaplain.
Have you ever testified differently?
Maybe you have it there, but that's what I remember today.
Do you recall, you said I'm sorry, can you repeat your answer? Have you ever testified differently?
I said that's what I recall today, what I just testified.
Okay, isn't it fair to say you previously stated that George was the one that told you his favorite nurse came into the room?
I may have. If you have it there, then I'll take your word for it.
Okay, and so if George is telling you it's his favorite nurse, but it's actually a unit secretary, that wouldn't be correct, would it?
Well, if she's not the nurse and she's a unit secretary, if that's what you say she is, then that'd be incorrect. If that's, I'm telling you what I've heard.
Do you know of any unit secretary that visited George on a regular basis such that it would be his quote favorite?
No.
And you were asked to be here to testify as a witness by Lisa Polidoro and her team. Is that true?
If David Cook asked you to be here.
Wouldn't it be fair to say that you have to endorse this will as being valid because it was prepared by your law firm?
Not necessarily, no.
Well, would it be true that if your law firm prepared a will for someone and had it executed for someone who is incapacitated, that could be actionable, potentially?
It may be, but like I say, that's not the motive for me being here today.
Fair enough. Objection unresponsive.
I think he got the answer though. Okay.
Before George got sick and George would deal directly with you on business matters, I'm sorry, let me rephrase that, excuse me. Before George got sick, you and George would deal directly with one another on his businesses, correct? Okay. When you were interacting with George, Lisa wasn't typically a part of those business dealings, correct?
Correct.
Okay. When there would be emails corresponding back and forth between George and title companies, those emails you produced in your files, Lisa's not copied on those emails, correct?
I don't know that she is. I would say generally not. No.
Okay, generally not. You testified that while George was in the hospital, you discussed issues concerning Memorial Turkey Creek tenants at that time.
I do recall that, yes.
Okay. When George was in the hospital, isn't it true that Lisa began handling the issues for Memorial Turkey Creek?
I think she, started doing that, yes.
Okay, and she didn't historically handle those matters, true?
Generally not, no, that's cool.
Okay. So give me one moment, I'm just. Isn't it true that there was an issue with the tenants at Memorial Turkey Creek not paying their rent?
There has been in the past, yes.
Okay, do you recall specifically that there was an issue with the tenants not paying their rent in February of 2022?
there may have been.
And you were communicating regarding that issue with Lisa, not with George, correct?
I may have been, with Lisa, I just don't recall specifically now.
Delay. Have a 5,000 sheet exhibit that I'm trying to print one page for. Okay. I'm going to show you an email that Lisa sent to you on February 10th of 2022 concerning the cleaners at Memorial Turkey Creek. Do you see that on your screen?
I do.
Okay. Do you recall receiving this email?
No, not really. I'm sorry.
But is it fair to say that this email was part of your production of business records?
It looks like it would be, yes.
Okay. And your name appears there in the to box?
It does, yes.
Okay. And isn't it fair to say that February 10th, 2022 is one day after the will signing?
That's correct.
Your Honor, I would offer this as exhibit 1F.
Yeah, may we approach?
Yes, certainly. Or you have a paper copy? Okay.
Okay, so Mr. Pappas, Your Honor, may I publish this to the jury or would you prefer me to?
Yeah, it's conditionally admitted. You may publish.
Okay, and it's 1F.
All right. 1F is conditionally admitted.
We'll get better at this as we try and put someone. Okay, so we were previously talking about this February 10th of 2022 email to you from Lisa about the cleaners at Memorial Turkey Creek. Is that true?
That we what?
About the cleaners at Memorial Turkey Creek?
That's what it's addressing, yes.
Memorial Turkey Creek was one of the decedent's businesses. Isn't that true?
It's a project, yes, it was a commercial project.
Okay, it's really a couple of entities that he created to hold commercial real property. Would that be accurate?
It was an entity for that specific shopping center, yes.
Right. And that shopping center is located here in Houston?
Correct.
And that shopping center has tenants that rent units out of that property?
Correct.
And one of them would be the cleaners that are referenced in this email?
Yes.
Okay. And so going back to the email itself, Lisa is telling you that the cleaners in Memorial Turkey Creek have not paid their February rent. Isn't that true?
That's what it says.
Okay. And you previously testified that Lisa did not historically interact with you on George's business matters. Is that true?
Yes.
But on this day, which is one day after the will is signed, Lisa is emailing you about one of George's businesses directly, correct?
Yes.
Okay. And George is not copied on this email, true?
No.
And then isn't it true that 2 days after the will is signed, which is February 11th of 2022, Lisa emails you to approve a draft of a letter concerning that same eviction issue?
I don't remember that, but be sure it's another glad to look at it.
I'm showing you a letter dated February 11th of 2022. Do you see that document on your
I do.
screen? And do you recall drafting this letter?
I don't, but it has my name on it, so I must have sent the letter.
It's fair to say that this is a letter that you produced as part of the records from your law firm?
It apparently is, yes.
And it pertains to the Memorial Turkey Creek property?
Correct.
And if I scroll down, you see the certified mail stamps for this.
I do.
Okay. And then there's an email that shows that document that's attached on February 11th at 11:14 a.m. to Lisa Polidoros.
Yes.
And her BCC is there at the bottom.
George and Lisa, yes, I see their names.
Okay. And then does she respond 2 minutes later to the draft of this letter?
My report looks perfect.
Your Honor, I would move to admit the email with the letter attached as exhibit 1G.
Any objection?
No objection.
1G is admitted.
And talking about this email where Lisa responds looks perfect. You testified a moment ago that you had emailed the copy of the letter to both George and Lisa, right?
Yes.
Okay. And, but when she responds, she does not copy George. In fact, she takes his name off of that email, doesn't she?
I just see, it's just to me, and then mine goes back and you can see where it was sent.
Okay.
Are you trying to publish and it's not working?
Yeah,
Okay. See what I
it
can
could
do.
be user error.
No, it's not user error. I'm just here.
And the email that you see up on that screen behind you, that's the one we're talking about, correct?
Dead show. So.
Yeah, that was right.
Okay, where she is responding to you, to an email you sent her and George, takes George off, responds to you directly.
Yes.
And this is 2 days after the will is signed, right?
February 11, yes.
Okay. Let's move on to a different topic. When you said you never experienced confusion from George, you're not a medical expert, correct?
No.
Okay, you couldn't testify to any of George's medical conditions that he was experiencing?
No, just my observations as a layperson.
Would it surprise you to learn that George was consistently experiencing confusion and memory loss as noted in his medical record?
I didn't see it. I mean, if the medical records say one thing, that's fine, but I'm just telling you what I saw.
Okay. Are you aware that George was experiencing confusion on February 1st of 2022 when Lisa's emailing you about changes to the will?
No.
Okay. I'm going to show you what's been previously admitted as CS and DP Exhibit 4.
As been previously admitted, but, okay.
Oh, I'm sorry.
Uh,
I apologize.
okay. Yeah, it was authentication only. It has not been.
I'm sorry, that was
It's okay.
an honest mistake on my part.
It's okay.
Mr. Pappas, I'm going to show you what has not been admitted, but what has been marked as C. Not. Has been marked as CS and DP Exhibit 4. Please let me know when you can see that. Do you see it on your screen?
I don't see where it's marked. I see a medical.
You have a Methodist document on your screen?
I see, yeah, you
Okay.
Methodist now, yes.
Great. And do you see, if we scroll down a little bit, do you see these tiny little dates entered here
I do,
under each entry?
yes.
And do you see, and I'm not going to quote from the document because it's not admitted to evidence. Do you see that George McPolidor's name appears at the top?
Well, if you can scroll down, I can tell you. Yes, I see George Nick Polidor's.
Okay. And do you see entries dated February 1st of 2022 here?
I do.
Your Honor, I would move to admit Exhibit 4.
The only objection I have is, he has no personal knowledge, he's looking at a medical,
We're not talking about authentication.
well, I understand that, but are we going, okay, that's fine. It's not authentication, it just has to do with him having no personal knowledge, and do you see that, do you see that, do you see that? Like, it's vice versa. Is that where we're going?
I think that's probably where we're going.
All right.
Uh,
That's fine.
Not hearing any other objection, then number 4 is admitted. This is from, you're calling it D and C, right?
CS and D.
Okay, all right.
What,
very good.
what particular page is this?
CS and D, number,
I am offering the entire record, Your Honor.
yes, you are offering the entire record, and I didn't hear an objection to the entire record.
Oh, I'm sorry, I don't know, the entire record is relevant, I mean, how long is the entire record? 15,000 pages. I object.
Can you be specific, though, because
This page may be relevant, the other pages aren't, I mean, there's pages and thousands of records that are not relevant, they may include hearsay, I mean, they may include hearsay within hearsay.
well, that hearsay problem's been knocked out because of the business records affidavit, so nobody objected within, was it 10 days? I can't remember what the time is.
Okay.
Yeah, so no objection was to hearsay prior to that deadline passing, then hearsay is not a problem anymore.
I'm sorry, I'm just trying to think quicker, she was talking about this.
He's talking about 15,000 pages.
You read that 55? Okay, what we talked about.
No, the full exhibit 4 is.
Okay,
All of exhibit 4.
all right, I understand that now, did not understand it now.
Oh, okay. I'm sorry, do you have an objection to all 15,000 pages? I'm gonna make the jurors sit down and read everything.
That's- It's just, okay. Yeah,
I'm sure you, all of you attorneys will direct the jury to what you would like them to read. You're not gonna have to read all that, I promise you. They will tell you what they want you to focus on later. All right, not hearing any other objection. Did you have something to add, Mr. President?
No.
Okay, I didn't see you did. Then number 4 is admitted for Dorothy Apollodorus and Christy Stovall's exhibit list.
Just what page is it, Judge? We don't know what page.
600.
10,655.
Looking at small notebook, some of these might be in there, and I'm not sure what Ms. Smith's reading, I know what I pulled up from my budget, so it might be all of them.
Yeah. 10,655, 55 or 65?
55.
That's in my little, okay.
Wait, what?
10,655.
55, yeah, that's in my little.
And I am using Methodist space labels, not the GMP.
Got it.
Oh.
And so, Mr. Pappas, for your reference, the bottom right corner has space labels. I'm using the bold ones from Houston Methodist Hospital if I'm referring to a page.
Okay. I'm with you.
So we were talking about this medical record a moment ago, and you identified some entries that you saw on February 1st of 2022. Is that true,
That's true.
on this page? Do you see here where a nurse notes on February 1st of 2022, Mr. Apollodorus was experiencing short-term memory loss?
See, that's what it says.
Okay, and isn't that the same day that you are communicating with Lisa Apollodorus by phone and email regarding the changes to his?
There was an email, yes, on February 1, 2022.
Okay. And I'm going to direct you to a few pages up. No one look at the screen. I'm turning you to 10,585. Do
Okay,
you see that base label there at the bottom right-hand corner?
I do.
Okay. And if we look at this entry here at the very bottom of the page, I'll put it in the middle of the screen for you. Is there an entry that says short-term memory loss on February 8th of 2022?
Yes,
Okay, and isn't that the day that you're receiving additional changes to the will and you made those handwritten phone notes regarding the changes?
that's the date, yes.
Okay, and again, you don't recall, as you sit here today, who you spoke to on the phone that day or have any knowledge of who wrote that email?
That's the one with the date stamp that there's GMP there, that's all I can tell you. And I don't know,
Okay,
I just assume it's George, but I can't tell you that for sure.
okay. And this entry on this medical record is one day before the will is signed, true?
February 8th, one day before February the 9th, yes.
Because the will was signed February 9th of 2022. And then if we scroll just a little bit to 12,504. Almost. Do you see entries on this particular date for February 8th, which is again the day before the will?
I do.
Okay, and then right above this, do you see an entry here on February 9th of 2022?
I see that date.
And that again is the date of the will, correct?
Yes, February 9th, 2022.
And isn't it true that there's an entry here on a confusion assessment method for all level of consciousness?
That's what it says.
Thank you. You've testified previously that you know George to be a strong-willed, analytical person, very strong in his opinions, right?
Yes.
Okay. And you've said that there's absolutely no way that he could be unduly influenced, right?
I don't know George. I don't think that's the case.
Okay. But isn't it fair to say that based on the medical records we've gone through today, that George was not his typical self during February of 2022?
He did have some problems, yes.
Okay. And because you weren't there in the hospital, you would have no way of knowing if he was unduly influenced or not, right?
Well, yes, I would.
You would know, even without being there, if someone had unduly influenced him in person.
Right. I mean, in my conversations, I would hear that or be told that, or I'd get some indication. I didn't have any indication. I wasn't told that. George was his strong self. You know, so no, I would know.
But isn't it fair to say, other than the brief conversations for 10 minutes or less that you had maybe once a week, you have no other knowledge one way or the other?
No, it's not true. I spoke to George after he was out of the hospital. And there was nothing that he indicated to me or any gave me any sign whatsoever that that was the case.
I'm talking about the period in the hospital, when you did not see him in person. You would not have any knowledge one way or the other. True?
Well, beyond telephone calls.
Okay. George wasn't an impulsive person, right?
More the analytical type.
He was very careful in his decisions when he was doing his business dealing.
I think that's a fair assessment.
Isn't it true that the emails in your record show him being a pretty hard person to negotiate with, right?
He had a thing, yes.
And he would take a hard line with some of his business transactions to make sure he's getting the best deal.
Well, he would do that, yes.
So wouldn't it be fair to say that signing a will on the fly in the ICU is not a characteristic of George?
I don't know if it's on the fly. I have to disagree with you there.
Okay.
We've been dealing for years on that.
And you have no idea, because you're not the estate planning lawyer, how much or how little went into preparing that will.
No, that's not true.
You weren't, but you didn't prepare it, true?
I didn't prepare it, but for years, I get emails, correspondence.
You also don't know how much input Lisa had into that will, did you?
She probably had some input, but I just, again, when my communication with George, I knew what he was putting into it.
Objection non-responsive. You do not know, as you sit here today, how much input Lisa Polidoros had into that will that was signed on February 9th.
I can't agree with that.
But we know that she had at least some, because those February 1st and February 8th emails that you received, right?
She sent me messages. I agree with it, yes.
And isn't it true that as we talked about his business dealings before, George expected people to pay their fair share in his business transaction?
I think that's a fair statement.
For example, it wouldn't be characteristic of George to forgive a loan. Fair?
Yes and no. If it was a straight up deal, George would bargain where he knew the other side. On the other hand, he was compassionate, and so if there was an extenuating circumstance, I could see George doing that.
Okay. As you sit here today, you're not aware of any other loans that George forgave during your 40 years of knowing him, correct?
No, that's not true.
You're aware of loans he forgave in the past?
Yes.
And to whom were those?
No, Mary Hart's loan was forgiven.
Okay. You're talking about the Mary Hart loan that was in his will.
Yes.
Are you aware of any other loans that he forgave during his life, specifically?
Can't think of any specific loans now.
But as you said, the 2022 will forgives the loan to Mary Hart, doesn't it?
It does, yes.
And we previously talked about Lisa's exhibit 1, which I believe is in the spiral bound notebook. Should still be up there, I believe.
Are you talking about the will?
The will, yes, I'm sorry.
Yeah, I have a will here.
Okay. Isn't it true that Mary Hart, well, let me start that. Let me ask this question. That loan forgiveness appears in the will, correct?
It does, yes.
Okay. If you'll give me one moment. If you'll turn to what's been previously admitted as Lisa's exhibit 1. And the portion of the forgiveness of the loan appears on the numerical page 3 of that loan.
I see it, loan of 20,000 shall be considered paid in full.
Okay. And to your knowledge, that's the only loan that you're aware of that George ever forgave, fair?
I'm trying to think back. I'm not avoiding your question, but for 40 years, I just, that's the one that comes to my mind because that's the most recent.
And isn't it true that Mary Hart herself sent you an email on March 8th to let you know her loan was forgiven?
She may have. I see some paperwork here. George.
If you'll turn back to exhibit 1B.
Okay, I'm there. I think that's we're on the second page.
What numbers on the bottom left hand side?
Sorry, I just want to make sure this is part of it.
Oh,
I'm being informed that it is part of exhibit 1B.
Very good.
Mr. Pappas, I'm showing you an email dated March 8th of 2022. Do you see it there on your screen?
I do.
And is it the subject of that email, loan forgiveness documents dated February 14th of 2022?
I'm sorry, what was the question?
The subject line of the email is loan forgiveness documents dated February 14th of 2022.
Yes.
Okay. And is it true that the body of the email addresses you and then says, George asked me to forward this document for your review?
That's what it says.
And then the signature block appears to be George, but if you look just up, it says Mary Hart 4. Do you see that?
It's from George Polidorus to Mary Hart. Happy Valentine's Day from George.
No, if you look up above George's signature block, it says Mary Hart 4.
Oh, I see that, yes.
So would it be fair to say that Mary Hart is emailing on George's behalf from his email account?
It does look like that, yes.
Okay. Isn't it true that Mary Hart had access to George's email account and would use it?
It looks like she did, at least on this occasion, yes.
Okay. And if we scroll down to the attachment, do you see this promissory note? Is that the promissory, sorry, is that the promissory note that you're familiar with for the $20,000 loan to Mary Hart?
Yes.
Okay. And it appears to be signed by George on February 12th of 2022. Do you see that?
That's what it shows, yes.
Are you aware that George's medical records noted cognition issues for George on February 12th of 2022?
I'm not, but
Do you need to see the cognition issues?
I mean, if you say it's there, I'll trust you. I've just not seen it. I don't know of that.
Okay, let's go back on to Exhibit 1, which has been previously admitted, which is the will. And isn't it true that there is a specific bequest to my son, Nick George Polidorus, for the funds on deposit for Moody, the 1037 account we saw previously, and then the 6899 account for Prosperity?
Yes, those are two accounts that,
You testified earlier that George was concerned about Nikki being taken care of during his life. Is that right?
yes,
One of the things that you testified to with Mr. Cook was that George was concerned about getting Nikki a place to live, right?
he was.
This will doesn't give Nikki a place to live, right?
No,
Okay. And he gives Nikki instead these two accounts at Prosperity Bank and Moody, right?
from the sale of Emmons property, yes.
Okay. Isn't it true that a person can't give away something that they don't own?
Be a fair statement.
Okay. And if we turn back to exhibit, can you tell me what the Moody page was? What was previously admitted as exhibit 1E? 14A, excuse me. Exhibit 14A. I'm going to show you that document one more time. Do you see it up there on your screen?
I do, yes.
And whose name is that account in?
Nikki George Polidorus.
Okay. So when George is giving away the 1037 account in his will, he doesn't actually own that account. Is that fair?
Well, you'll see George Nick Polidorus rep payee. And so I'm not sure as far as the ownership of that account. I don't know who's the signatory on that account. I just can't tell you who actually owns it.
Right, but it's fair to say at least even if a representative payee were able to own a checking account, that he would not be the only owner, right?
It would depend on the arrangements as far as, you know, if it's a power of attorney, whatever the case may be. I'm not prepared to tell you one way or the other because I don't know what the arrangements were.
But Nikki is listed on this account, correct, as an owner?
With George Nick Polidorus rep payee.
Right. So George's will actually gives an account away that he, at least in part, may not own.
I don't know about the ownership.
So if we have an account listed in both of their names, either George didn't recall that he was only a part owner, or that information was given to you incorrectly. Fair?
I don't know enough about the account. You remember there was some language in there about Christy and Dorothea holding it, so I just don't know enough about the account to tell you.
Objection non-responsive as to everything after I don't know about the account.
Okay.
But, and last question, would it be fair to say that the will gives away an account that at least was partially not in the decedent. Based on this statement.
I don't know enough about it, just, to give you an answer one way or the other.
You all want to continue?
You may.
All right, thank you. Kyle, I'm gonna work this very quickly. I did not have the record in front of me at the time. If you'll turn to exhibit number 2 from the book that was magically appeared next to your leg. Do you see that? Yes, would you look at that?
Yes.
Can you check to see if there are any missing pages or what pages are missing from there?
We approach.
Sure. Come on. Mr. Followers. Mr. Pappas?
Yes.
I'm going to ask you a question, and I'm just, based on the communications that you had with George, okay? The communications you had with George prior to going into the hospital, okay? I want you to base your answer on that. I also want to base your, I also want you to base the answer to your next question on the communications that you had with George while he was in the hospital, while you were talking to him on the phone. You understand that? Okay. Could you verbally?
Yes, you want me to articulate what his condition was when he was in the hospital?
No. I'm going to ask you a question, but I want you to base it on the communications that you've had with him throughout his life as a friend related to what he wanted to do, what you testified about already about his estate plan, and the discussions that you had with him while he was in the hospital. Okay?
Is there a question on compound?
No, he's laying a foundation for his question.
Okay.
Overruled.
Okay. So based on those communications and that long relationship you've had with him, was it clear or was it or was it not clear that Lisa was writing the terms of George's will down because that's what Lisa wanted, or was she just forwarding notes to you?
Objection leading and.
Not leading. Can you rephrase the question? Overrule is leading. Can you
Based
rephrase?
on that same, based on all that past records and history of communications, was it your understanding that Lisa was forwarding notes to you from George, or was she actually forwarding her decisions and what she wanted to do with George's estate plan?
Judge, I'm just gonna object to the form to the extent he's going way back in history, that's not relevant. It's relevant around the time before, after, shortly before the will, and especially in the hospital, in the ICU. So George in 2015, 2016 is not George.
But no, I think that proposition is agreed to, but do you want to respond to that?
Well, yes, I'm just trying to summarize discussions that we had with George. He talked about his estate plan prior in advance for many years. He also talked to him about the discussions that he had while he was in the hospital. So this is just his understanding of, based on all of that and the recent discussions that he had.
Asking about a typical course of business between him and his client's wife?
Yeah, no,
Did I misunderstand?
understanding, those documents that he received, did he receive those, were those Lisa's wishes or were those George's wishes? It's just simple as
That's
that.
what you're asking. Okay.
I object to the form to the extent it includes a bunch of testimony from way in the past, that is before 2022, 2020.
I think his question now is the documents that were received right before the new will was created, was that, in his opinion, George's wishes or Lisa's wishes? I think that's really what he's asking.
That's a different question that I'm hearing.
Is that, did I misunderstand your question?
No, that was my question.
I thought I understood your question. Why don't you try one more time very clearly to ask what the question so that we all can determine whether or not there's going to be some objection.
Okay, it was handwritten notes that George signed, all right, you know what I'm talking about? I do. Were they, did you believe those to be George's wishes on what he wanted to do with his will, or did you believe that to be Lisa's wishes on what she wanted to do with his
Objection,
will?
speculation.
Overruled, it's his belief.
No.
You may answer.
Thank you, Judge. Knowing George as well as I did, I'm convinced that those were George's wishes and directions.
Okay, thank you. You then received these notes that were forwarded to you by Lisa. Do you recall that? You had it in the email. You remember that? And then you took those notes and forwarded them to Monty.
Objection leading.
I'm sorry. You took those notes and then to whom did you forward them?
Monty.
Okay. Do you feel like that you were participating in the will, the drafting of the will?
I didn't draft the will. I passed the notes on and the wishes that I heard and that George provided to me. So that's what my role was.
Okay, you're simply forwarding the notes to Monty,
Objection leading.
right?
Sustained.
Okay. What were you doing with those notes?
I was communicating those to Monty because I knew those were George's wishes.
Okay. All right, I don't necessarily want to go back and forth, but we could look at these records. Do you recall the records that you were looking at that were notes? I think you testified they were notes that you wrote down after speaking with George. Do you recall that?
Yes, I can find those.
Okay. Well, one of them is 39747. Yeah.
Yes, I have that. That was a note from my conversation with George.
Okay. And in these notes, he's referencing property, right?
Yes,
Okay. Did you, are these the same notes that are, same property that he's referencing that ended up being in his will? Do you recall that? We talked about that? Okay. All right. And then if you go to the next one that they were talking about is 39732. Do you see that? 39732.
Let me see if I can help you out.
Okay.
Which check?
Um,
It's the same, just turn about 3 or 4 pages, 39732.
or 732, I have, yes.
That's, we've all seen it, we can talk, you can talk about it, what do I remember? 39732, okay, and it talked about, if you look on here, it references, an account, the bank account that had the Timmons, the proceeds of the Timmons lane in there.
Right.
Right. Do you know if that account had the proceeds of the Timmons lane in it?
I don't, I just took notes and I don't know what was there.
Mhm.
I just know that what I wrote down, what I heard, and then I wrote down this and the SSI. So that's what I know.
Okay, and then he also referenced this other account, he says GNP trustee, SSI money.
Yes,
Was that, other than the amount, was that an accurate reference to that account?
right. George had concerns about SSI and the impact on Nikki, and so that's what that was all about.
Mr. Cook, let me just interrupt real quick. I do a little IT thing. That's that cord that doesn't work. It's the cord that doesn't work. So unplug the HDMI cable from the document camera in the back there. And try to see if that works for you. Okay, there you go. All right, now let's try that again. Okay. All right, I didn't mean to interrupt. I apologize. Go ahead.
That's okay, and I'm just gonna ask this question, I don't know if you got to answer it earlier, but, after all those, after the discussions that you had with your friend in the hospital, while he was in the hospital, you recall that?
Right.
Okay, and I think they showed you some medical records, do you remember that? I think they showed you 3 medical records, did you see that?
I remember there's some background.
Okay, like 15,000 pages, correct?
Well, I saw 3 pages, thankfully, not
Okay.
15.
And then, she didn't show you the times on those medical records, did she?
I saw sometimes, yes.
Did you know when those times were?
I noted, for instance, February 1,
Mhm.
and some had time, some didn't.
Okay, you were talking with George at 4 AM, were you?
No,
You weren't talking with George at 11 PM, were you?
no.
Okay,
Objection leading.
Sustain.
okay, that's what.
May I proceed, Your Honor?
You may.
Yes, sir.
Okay, Pappas. You answered a question from Mr. Cook just recently about the communications that you received February 2022. You remember that? You gave us your opinion about George's capacity, correct?
I've given you
Let me try to cut to the chase. The information that we've got in 1C that you and I talked about earlier, these all came from Lisa, right? The email, hey Dan, these are things I wrote. I wrote today for the will. This is Lisa, correct? That came from Lisa, correct? And this handwriting, substantive handwriting about the items, that was not written by George, that was written by Lisa, correct?
You're gonna have to ask her. I don't know. I said it before, who can.
Well, let's just see, you were able to give them an opinion about somebody that is George, that you said in your deposition couldn't breathe, couldn't communicate because of problems with his lung. You gave him an opinion, a stirring opinion about his capacity. My question is, can you give us an opinion? This is clearly not George's handwriting, correct? And then clearly Lisa says, things I wrote today for the will, correct? Can you give us an opinion that if you scroll a little bit more, you can see this nice handwriting. So can you give the jury an opinion that that was by Lisa, most likely, since she said in the cover email, these are things that I wrote today for the will?
I would guess that too.
Okay. And you mentioned something, you've been talking to George for years about this will, correct? About
a long time, yes.
Yes. So how many years do you think it was?
I know there were conversations after the 2015 will, so.
Okay. And so from 2015 to 2022, so from 2016 to 2022, you never signed a will, did you, that you know of?
I don't know the will that was signed in between.
It wasn't one that you know of, correct?
Again, I don't know of one.
And would it be correct to say that in 2016, 17, 18, 19, and 20, we probably had the strong George Polidorus at that point, didn't we?
I think you're right. George was strong, yes.
All right, what about the George Polidorus in the middle of his stay at Methodist Hospital, where there are 15,000 pages of records generated for his medical condition he was suffering from? In the middle of that, in the ICU, that's not the same strong George Polidorus, is it?
He had some, no question about it, he had some lung problems, he had some issues, that's correct.
Well, and you said in your deposition, he couldn't breathe and you couldn't communicate with him, correct?
I had a hard time communicating with him sometimes, and he did have breathing problems, there's no question about that.
Doesn't it cause you a little pause to think, for 10 years or so, he's having all these conversations about his will, it's a strong George Polidorus. He never signs a will until he's sick on death's door. He signs a will consistent with the terms that come from emails and handwritten notes from Lisa Polidorus. Doesn't that cause you
some concern that he talks about it for years, but he doesn't sign it until he's in the ICU on death's door?
Not under the circumstances.
What if, did you know that they were talking about palliative care for him on February the 12th? 3 days after he signed this will?
Again, under the circumstances that I know, I can explain why.
But did you know that they were considering palliative care?
No, I didn't.
All right. I pass the witness.
Thank you, Ms. Smith.
No further questions.
Any further redirect?
Ms. Pappas, thank you.
Mr. Pappas, you may step down. Thank you. Is Mr. Pappas subject to recall by anyone?
I don't anticipate recall at this time.
I don't need.
May we excuse him from the trial then? All right, thank you, Mr. Pappas. You're excused from the trial, Judge. All right, with that, why don't we take about a 10-minute break and we'll pick up again with are you going to be ready for your next witness, Mr. Cook?
I'm gonna rearrange just because of the way the time is, so yes.
Okay, very good. So let's take about a 10-minute break, come back at about a little after 3:30 and we'll continue on.
All right, so Jerry,
Maybe see it. And just to let you know, we have 2 more witnesses that we're gonna try to get through today. I don't think it's going to take terribly long, but we may go beyond 4:30. I think it's for efficiency. Let's try to get them through today, because they've been waiting out there. Okay? But just let you know, if you're a little later than 4:30. All right. Mr. Cook?
Chuck Hawkins, please.
Chuck Hawkins.
Chuck Hawkins.
Good afternoon, Mr. Hawkins. Do you solemnly swear or affirm the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You may take a seat.
Good. Mr. Hawkins, would you please tell the jury who you are? Or just tell me, whatever.
I'm Chuck Hawkins. I've lived here in Houston in the Pearland area since 2008.
What do you do for a living?
I'm a full-time clinical chaplain at Texas Children's Hospital. Did church music full-time for about 27 years throughout Texas, and then did a career change in 2008, moved down, did a year residency, went to work, and I've been doing chaplaincy ever since.
Okay, you said you're Texas Children's, is that what you said?
Right, I was at Houston Methodist for 15 years, some time off, and then went to work at TCH back in February.
Okay. Houston Methodist, is that where you met George Polidorus?
It is.
Okay. I have put an original document up there. If you will take a look at that document,
Okay.
and I'm just gonna ask you some basic questions right now, and then we're gonna move on with the rest.
Okay.
Have you seen that document before?
I'm assuming my signature is on here, so yes.
Okay, all right, and I'm gonna ask, is that your signature?
Yes, it is.
Okay, and then do you also see other signatures on
I do.
there? And whose signatures are they?
Jessica Laster and notary. I can't really read the first name. It looks like Donaldson.
Okay. Anybody else sign that document?
Mr. Polidorus.
Okay. All right, and when you sign that document, where were you?
We were in his room there in the hospital.
Okay, and when the document was signed by everybody who signed it, all the people you just referenced.
Right.
Was everybody in front of each other at the same time when everybody was signing it?
Yes. Mr. Polidorus is, let's say, we're kind of at the foot of the bed. He's there. The attorney was more at the foot of the bed, and myself and the other witness were kind of over to the right a little bit.
Okay, but everybody could see each other.
Yes.
Okay, great. That's all. I'm going to ask you about what happened, not necessarily the document any longer.
Okay.
I don't know that you're going to have to reference it. We may throw the document up on the screen.
Okay.
Okay, good. All right. When you met Mr. Polidorus, you said you were working at Houston Methodist. What was your role there at that time?
I was a full-time chaplain, and I had specific units there at the hospital, or like floors in the building. Each chaplain has assigned units, and one of my assigned units, turns out, Mr. Polidorus was a patient.
Okay, and in your role as the chaplain there at that church, what did you do on a daily basis? Just, and I don't mean every single day when you walked in. Typically, what did you do?
Well, the majority of my day was spent seeing patients. My primary unit was an ICU, and so I spent plenty of time there because those were very, very sick patients. But then I had two other units, one of which was the one where Polidorus was, and so if I wasn't in MICU, I'd be at one of those other two units, one in the Dunn building and one over in the main building. And I would go to that unit, check the census to see who hadn't been seen or anybody that hadn't been seen for at least a week. And I'd start out by rounding, and for the ones that hadn't been seen, you know, it wasn't our practice to do a hard sell. We didn't go into the Bible and hope.
I was gonna ask, when you walk in, is that, oh, pastor?
Yeah, we had this swinging smoke thing.
Okay.
No, we just, we would go in because our role there.
Your Honor,
Okay.
I'm so sorry, Your Honor. I just have to object to the narrative.
Sorry?
Object to the narrative.
If we want to do this in question and answer, we can. This is kind of a getting to know you thing. You want question and answer on this?
I do, yes.
All right, so stay in question and answer only then.
Okay. All right, thank you. All right, so, all right, I think you were saying that it wasn't a hard sell, and I don't know that we need to go into it, but I do want you to at least be able to finish your answer. It wasn't a hard sell, so what does that mean?
It means I would introduce myself to the patients I'd never met before, make them aware of our because we had 24/7 coverage, make them aware of our availability were they to have any non-medical needs, including emotional and or spiritual. And so our desire is to communicate to all the patients of any faith or no faith. We're glad to serve you if there's any way that we can.
Okay. So is this how you met George Polydorus?
It is.
All right. Tell us about your initial meeting, if you recall that, with George Polydorus.
Right. Again, it was an initial visit. I said along the lines of what I just cited to you. And I went on in the room. Normally I do that at kind of a distance. That way it makes them more comfortable to say no thanks if they don't want us in the room, which is cool. But so we engaged just in a little bit of chit chat. I don't really remember what we talked about.
Let me stop you there, just so we're doing our question and answer. And then what happened? Just kidding. All right, so I don't want to ask about what George said to you at this point, because you said it was just chit chat. When you were talking with George at that time, during this first call, this first discussion, was did he appear confused to you?
No.
Okay. And when you talk about chit chat, was he talking about, you know what he was talking about overall? I mean, just.
I honestly don't remember it, just small talk, you know, nothing of a serious nature.
Okay. Did you guys have a good conversation?
As I recall, we did, and then he segued from that into kind of what we're here today for.
Okay. Well, let me ask you that. You said he segued to something else. Tell me, did you guys, what did you talk about as it relates to his will?
He said that he had an attorney who was coming to the hospital, coming to his room, and that he needed me to help him line up a witness or two.
Okay.
I explained to him that because it was a legal document and not a medical legal document, it's not appropriate for me to pull in a family member of a random patient to come in and witness his legal document.
Okay.
And he said, well, will you witness it? And I said, yes, sir. Sure, I'll do that.
Okay. So when you were with him and talking at this point, this first meeting, was anybody else in the room?
No.
Okay. But he seemed to remember that he had a will and he wanted somebody to sign as a witness.
Oh, he was.
Objection leading.
Okay. How long did this conversation go on for? With respect to the witness?
Oh, about the will?
Yes.
Not terribly long. As I said, he stated that he needed a witness. I agreed to do it. I gave him my business card, wrote my mobile number on it. as he knew that the attorney was coming to the room at some point, he knew it wasn't gonna be that day, and he wasn't sure, and I said, it's fine, I'm here weekdays, until whenever. So I gave him my card with my mobile, and that was it.
Okay. So did you see him again? Do you recall if you saw him again after that meeting before you signed the will?
No,
You remember how many days it was between the two?
it would just be a guess, I'd say, maybe a day or two, it hadn't been terribly long.
Okay.
It'd been long enough that I still kind of had it in the back of my mind and kind of crossing my fingers that he had discharged and I wasn't gonna have to do it.
All right. Why are you reluctant to sign or why were you reluctant to sign?
Well, as chaplains, our work is specifically on behalf of Houston Methodist Hospital. And as such, that work, that service is for patients, family members or friends of patients who come to the hospital, and then the staff that work there. The only documents that we're personally involved in executing are called advanced directives. It's a medical power of attorney and a directive to physicians. So when I agreed to witness the will, I wasn't exactly sure that was okay, but I wanted to help him. I mean, that's not unique to him. I'd do pretty much anything for patients, but.
All right. Before we talk about going back on the day of the will, let me ask this. As a pastor working at the hospital, do they give you any kind of special training related to signing legal documents?
For the advanced directives, yes, that's part of that 1 year of CPE, the residency, where we have class 2 or 3 days a week. And then we also round on the assigned units of the chaplain that we've been assigned to. But during CPE is where they introduce the medical power of attorney, the directive to physicians, they explain how to fill it out. They explain getting witnesses, they explain specifically about ensuring that a patient is alert and able to speak for themselves, because although we're helping them, we're assisting them in drafting the document, once it's done, it's a legal document.
As part of the training, did they show you or talk to you about red flags? About you said to make sure that they were alert and able to sign the document. Were you informed about any red flags to look for?
We were, but in a hospital, there's a pretty broad spectrum of things that people come in with. Sometimes the patients would not be alert, either as a result of the illness they came in with, or on some occasions as a result of some of the meds they were being given. So we were taught that if we had any hint that the patient was confused, a little unclear on anything, that we were to ask them some basic questions to determine their clarity.
Okay. And then, did they raise any red flags about perhaps a family member who was pushing or urging a patient to sign a document?
I'm sorry, laughing. We dealt with that all the time. And I'm not laughing at them, it's just that the patient would not be in shape, would not be in a place, in a state so that they could help. God bless the family members, they're needing to get these documents done because, it's kind of up in the air where the patient's going to go once they discharge. And so, but I mean, we routinely just had to explain to the family members that you're not able to execute that document because it's legal. The information we obtain has to come directly from the patient. And obviously, the patient has to know not only what the document it is and what they're doing, so that we know that they're clear when they select these people, the names of these people to put on the document. Because that directive to physicians, that's the document where the person states whether or not they want to be on mechanical support if they ever reach that point. And so that's critically important.
Okay, and then let me ask you this, as far as your training goes, if you've been taught how to look for red flags, if you see a red flag, then what are you supposed to do?
If I see any type of red flag, then I would just, at first I would ask the patient, do you know where you are? Do you remember who I am? What I do? You don't have to remember my name. What do I do? Do you know what today is? Do you know what year it is? Now, I wouldn't necessarily ask all of these. Usually you could ask 2 or 3 of those, and if they missed them all, then that was. But if I sense that the patient wasn't answering those questions correctly, I would just ask the patient to excuse me. I'd go out and find the patient's nurse, tell him or her, working on this document, I'm not sure he or her is alert. What can you tell me, medic? How have they been today? Is this, of course, they don't give me medical information because that's out of my lane. But they can tell me whether or not the patient's been confused, and so I would check with the nurse. And if the nurse confirmed that there had previously been issues where the patient was confused, that was the clincher for me. I'd go back in, and if there were family members there, I would explain to them why I couldn't execute the document, and I would tell the family member, please feel free to call me, tomorrow or the next day if this person clears up, which in cases does happen if that confusion is driven by meds. Call me. We'll come up and do another quick Q&A. If they're clear, we'll knock it out.
Okay. Let's move to when you came assigned the will. All right. How do you know that the will is going to be signed on that day?
A nurse, I think it was a nurse, called my mobile and said, hey, the attorney's up here for this patient in whatever room it was. I knew immediately who it was, so I dropped what I was doing and went up.
Okay. All right. And when you entered the room, who all was in there at the time?
The attorney was already there, and the other witness was already there. I guess I was the last one to show.
Okay. And anybody else in the room?
Not that I recall.
Was George in the room?
Oh, I'm sorry. The patient was in the room. Yes.
Tell me, overall, it doesn't have to be in minutes, but how long do you think you were in the room from coming in, signing the bill, and leaving after?
Longer than I wanted to be.
Okay.
His attorney read this document to myself and the other witness, specifically detailing and explaining what we were doing, making sure that we were okay with doing that, and then he turned to Mr. Polidorus, and he had an even longer document that he read, making sure that he wasn't being coerced, and asking him, are you alert, are you of sound mind, and I don't remember what else he read, but anyway, we were probably in there 15 minutes.
Okay. All right. And during this period of time, did George seem to understand what was being said?
Yes. Yes. I mean, especially when it came to the attorney addressing him.
Okay. And was he conversant, or was he just saying, what was he talking?
No, I mean, he answered yes or no, but it was obvious by his expression and his eye tracking and all that he was nodding and understanding what the what the attorney was saying to him in terms of his responsibility before signing the document.
Okay, did it appear to you that he was on, I think you said medications earlier that would affect his ability to sign documents? Did it appear to you that he was on medications that would affect his ability to understand what he was signing?
No, neither then or when I first visited him did I get any hint of that.
Okay, what time of the day was it? Do you recall when he signed this will?
I don't.
Okay, was it 4 a.m.?
I'm sorry?
4 a.m.?
Lord, no.
Okay,
I get back there at 6 a.m. No, no, it would have been between the hours of 9 and 3, because I was tied up every morning until 9 with departmental issues. And then because I came in at 6, I left at 3.
okay.
So 9 a.m. to 3 p.m.
All right. Is there anything that indicated to you while you were in there and watching all of this, watching Mr. Polydorus, that it didn't look like he could think clearly?
I'm sorry.
It didn't look like he could think clearly.
No, he was clear. He was fine.
Okay, this is Lisa Polydorus. Was she in the room when you were signing the will, listening to George?
No, I don't think we've ever met.
Okay.
I don't recognize her.
Okay.
No, there was, both times there was no one else. I was alone with him in the initial visit, and then in the signing, it was the people that I listed earlier.
Okay. I'm just gonna ask you a couple of questions real quick. Did he appear to talk slowly or respond slowly?
No, there was nothing like it.
Okay. Did he seem to understand that he was in a hospital, or did he think he was somewhere else?
Oh, no, he knew he was in the hospital.
Okay. Did he appear to know who the attorney was that was talking to him?
He did.
All right. Did he have any difficulty speaking?
No,
All right. Was there any long slurs or kind of speech impediments or anything?
no, because as I stated earlier, that would have been a red flag. If he'd been slurring his speech or giving any kind of indication, yeah, that'd have been a red flag.
Okay. And there's going to be some indications in the records that show that he was confused. And I think it's 4 a.m. or 11 a.m. around that period of time. Would that have concerned you if the nurse said, well, you know, at 4 a.m. last night, and he was kind of confused? Would that have concerned you speaking with him on that moment when he was signing this will?
Well, I mean, it would have heightened my attention to his condition when I went in the room.
Okay.
As I stated earlier, patients, they can have adverse effects, or maybe it's the typical effect. They can be confused and within a period of time, as the medicine wears off, they come out. But no, it would have heightened my attention, but I wouldn't say confused.
Okay. And knowing all of that, would that have raised the red flag where at that point, talking with George, signing the will, having the communications with him in advance, would you have said, no, I'm not going to sign?
I mean, not until I talked, went into the room and assessed his interaction with the attorney. I mean, he spoke to me when I came in, and no.
And did he remember you when you walked in that room? Did he say, who are you? Did he remember who you?
Oh, yeah, he knew who I was. I mean, he didn't call me by name, but he.
I'm sorry, I have to hear this objection, I apologize.
Hearsay.
Sustained.
Did it appear to you that he knew who you were?
Yes.
Okay. All right, I want to put up on the screen just that long paragraph that the attorney might have read to you. I'm going to ask you this real quick. So last page. Boom, there it is. All right. You see that in the middle where it says the undersigned, and it says Jessica Laster and Carol Hawkins? Do you see that?
Yes.
Okay. If you read all of that, I don't want you to have to read it out loud. But if you read all of that, can you confirm or deny that that's what Monty Donaldson read to you?
That's it.
Okay. All right. And did you swear to all of those statements in there?
Yes.
Okay. And at the time, as you were in the room, looking at him, talking to him, did you swear that he was innocent?
That he was what?
Of sound mind.
Absolutely.
Okay. Would you have signed this document if you believe that he was under any kind of influence, or if he would, I'm sorry, I thought that was an attorney. Or if he was, of unsound?
No, especially because I never did and would never help a patient execute the medical power of attorney if they weren't alert. I'm certainly not going to put myself out on a limb, somebody's last will and testament.
Objection, not responsive to everything else.
Sustain.
Okay, why would you have hesitated, and not signed something? Why was it important to you to swear that he was of sound mind?
Well, again, because it was a legal document.
Okay, and would you have put yourself out there, if you felt like there was any risk that he was not of sound mind?
No.
Okay, why not?
Because I liked my job.
Okay.
As I stated earlier, I was a little unsure even in terms of hospital policy, it was okay for me to even be a witness. So, I found out later it was okay, but they didn't
Objection,
necessarily.
non-responsive to everything after.
Sustain.
Pass the witness. Thank you, Mr. Hawkins.
Thank you. Mr. Christopher or Ms. Bobadian?
Mr. Hawkins,
Okay.
hey, my name's Jessica Bovadia, and we spoke briefly last Thursday, correct? Just
Yes.
to introduce ourselves and trying to figure out, where we were going. Have you watched any of this proceeding via live stream, YouTube, any other live streams?
No,
Just checking. And is it your testimony today that you've never met Lisa Polidorus before today?
that's correct.
And, have you ever spoken with her before today?
No.
And do you know Jessica Lasker?
I mean, I know her, I noticed her name is on this document, but I don't.
Do you know if she worked at, Houston Methodist?
I don't know.
Okay, and I'm gonna ask the next question, I think I know the answer, but do you know what her position was at Houston Methodist?
Oh, she was there? She was at HMH?
Do you know what her position was at Houston Methodist? If not, you can say I don't know.
No, I don't.
And on February 9th, 2022, I need to clarify your earlier testimony. What unit was George Polidorus on?
Now, my memory here is not perfect. I think he was in the main building. As I said, I had a unit in Maine and a unit in the Dunn building. It would have been one of those two because he wasn't in ICU.
Did you just testify he was not in ICU? I'm sorry, I didn't hear you, sir.
That's correct. No, when I met him, he was not in ICU.
On February 9th, 2022, the day of the will signing, would it surprise you to learn that the medical records indicate that he was in the intensive care unit on that day?
Well, not necessarily, to be honest with you, with the
Objection,
number of
non-responsive.
patients.
Sustain.
Do I answer?
No.
So if the medical records indicated he was in the intensive care unit, would you have any reason to disagree with?
No,
But you sitting here today don't remember what unit he was in.
no, I don't.
You remember what you ate for breakfast on February 9th, 2022?
Me?
Yes, you.
Probably nothing. I'm a coffee drinker.
Okay. You remember what you ate for lunch?
No, ma'am.
And you have some very specific memories of February 9th, 2022, correct?
I do.
But you don't remember what you ate for lunch.
Correct.
Have you done anything to prepare for your testimony today?
The only thing I've done to, I guess you call it preparation, is I read back through and have looked at the document that I typed up. Would have been, I don't know how long ago, and gave to Mr. Cross.
Okay,
I mean, Cook.
that's fine.
And that is the affidavit dated August 9th, 2023.
Correct.
And you typed out that affidavit?
I did.
Would you say your memory was better today or on August 9th, 2023?
Office.
I I'd have to say it was better then.
When was the last time you spoke with Mr. Cook in this matter?
Specifically about the details of this, of the case?
Yes.
Well, I mean, I'd have to check my phone to see the last time. I mean, I know we've talked about what time to be here, but in terms of discussion specifically about the case, it's been, I don't know, a couple of weeks.
And we spoke, you and I spoke on or about March 20th, 2025, correct?
We did.
Okay. And when we spoke, did you tell me that it was your belief that Mr. Cook's office told you that you could not or should not speak with me, other counsel in this case?
I did say that and then corrected that.
Okay. On March 21st, 2025, you called my office back, correct?
That's correct.
And you spoke to my paralegal, Terry Jacobs?
Correct.
And you corrected it by saying that you believed that he wouldn't want you to speak to me. Is that fair?
No, ma'am. What I said was I misspoke. And that what I intended to say was I wasn't sure if he would want that or if that would be okay. Maybe I watch too much television, but.
Objection, unresponsive objection. Okay, Mr. Hawkins, why would you have any reason to believe that, Judge. Are you represented by Mr. Cook?
No,
Are you represented by Mr. Cook's law office?
no,
Did Mr. Cook ever instruct you couldn't talk to any other counsel?
no,
You are a third-party witness, correct?
correct,
You're a hospital employee that witnessed a will.
correct.
Why would you think there's any reason that you couldn't speak to other counsel on a fact-finding mission in this matter?
So what I was about to say earlier was, I guess I've watched too much television. I wasn't aware that opposing counsel could call a witness and question them prior to the court date.
Now, did you send a draft of this the affidavit you signed to David Cook's office?
Yes, I did.
Was it sent to him before you drafted it? Or I'm sorry, before you signed it?
The affidavit?
Yes.
Well, I typed up on the computer, my computer, the affidavit, and I guess then it was typed up and I signed. I don't remember if I signed the original one that I sent him.
Okay. I guess my question is though, did you sent a draft to him before you signed it?
I'm not sure.
Would it surprise you to know that the notary on there is Carmen Castro Vasquez? Carmen Castro Vasquez, you know who she is?
I don't.
Where did you notarize the affidavit? Where did you sign it and have it notarized?
I honestly don't recall having that done if I didn't do it in conjunction with their office.
You signed this affidavit on August 9, 2023, and it was notarized, and you don't remember where you did that or the circumstances surrounding that?
I really don't.
Okay, thank you. You now work at Texas Children's, you worked at Houston Methodist, and I assume both hospitals have EHR, electronic health record, which is probably the bane of your existence, like everybody else.
Yes.
As a hospital chaplain, did you have any requirements that you had to notate visits with patients?
Yes.
What were those requirements? What were you required to do?
Well, the system is called Epic. We had to open the patient's chart. Of course, we were trained, obviously, that there were areas of that chart that were we to wander into those, we would be immediately terminated because we're not medical staff. But I would go in and basically note the time, and if there was anything unique or special about the visit, I would notice it. Typically, for like the first visit with patients, I would just type something in like initial visit, something pretty brief.
So if I told you in reviewing the Methodist record, I see three different, entries for you. One on February 2nd, 2022, one on February 4th, 2022, and one on February 8th, 2022. Does that sound fair?
That would be fair.
Do you remember what date George asked you to witness as well?
My memory is that it was at the first visit.
On February 2nd.
Yes.
Okay. Is that something outside of the norm for you, that somebody would ask you to witness a will for them?
Yes, it is.
Is that something that you anticipate you would have notated in the record?
Honestly, I don't know that I would have charted that event simply because it was something I had agreed with him to do, and it really didn't have to do with any kind of hospital visit or something in my role as a chaplain providing us an emotional or spiritual service.
You didn't think it was something important to note for the record, though, for the medical records, to let everybody know what was going on?
I mean, I guess not. I mean, like I said, if I didn't chart it, and apparently I didn't, it was, as I stated, it was because I went up, served the patient in the way I had agreed to do, and then went back to what I had been doing.
And sir, I think is there a similar one here?
Yes, sir.
If you go to tab 4, and we're gonna start, you've got to flip through it, and I apologize. Oh, is there a smaller way? If not, it will pop up on your screen in a second. We'll get it on your screen.
Okay.
So if you look at, the case number 002256. No. So this is what your notes look like, correct?
Yes.
If you keep going down,
Mhm.
you'll note that there's really no notes in there. It's that you visited with George, it's follow-up,
Mhm.
5 to 15 minutes,
Right.
no religion, no consult.
Right.
No other notes in there, correct?
Correct.
And if I told you it was the same on 2-4, would you believe me? Or do you, we can go through it, but would you believe that 2-4 also has no notes in there?
Yes.
Okay. And 2-8 also has no notes?
Mhm. Correct.
Are you supposed to chart in the patient's chart every time you go into their room and interact with them?
We weren't required to necessarily free text a chart note. The
Objection non-responsive. The question is, when you interface with a patient,
Mhm.
not whether or not you can put detailed notes, when you interface with a patient, were you required to put a notation in the system, just like on 2-2, the form note I encountered with the patient?
No,
You were not.
no.
And do you know who Michael Liga is?
I'm sorry.
Michael Liga?
I recognize that.
Well, can you go to 2-2? Michael Liga, according to the records, is another chaplain.
Oh, he's one of our residents. Yes, Mike.
So if you look at Michael Liga's notes, you can see they're a bit more detailed, saying 5 to 15 minutes, referral from rounding. So Michael Liga, the day after the will is signed, there's a referral from rounding.
Mm-hmm.
If you go down to rounding, it says, I visited with George and Lisa White. They're appreciative of the hospital's prayers. George shared that he's having issues sleeping and that his mind keeps working and is. Did you never experience that with George?
No, not at the times I visited him.
Would you be surprised that's not the first time that his anxiety is notated in the records?
Well, I would have no way to know.
Did you ever talk to him about being anxious?
I wasn't aware that he was.
Did you ever meet any of George's children?
I'm
Did
sorry?
you ever meet any of George's children, George Junior?
No.
Jesse?
No,
Did you know their names?
no,
Did you know anything about George's estate, his assets?
no,
Did George ever offer any information about that to you?
no.
Do you know if it was a simple estate or a complex estate?
I had no idea.
And when we're talking about George Polidorus, I think, does it sound right that you met with him 3 times by February 9th, 2022? Is that fair, do you think?
Well, according to the records, apparently so.
When you met with George, was he wearing any assistive devices? Hearing aids, glasses, hearing amplifiers, anything like that?
Gosh, I honestly don't recall.
On the day of the will ceremony, do you recall if he's wearing a hearing aid or glasses?
I don't.
Did you ever notice that he's hard of hearing?
No, I didn't.
Did you ever find yourself speaking more loudly in the room with George?
Not that I recall.
Okay. I know we talked a bit where everybody was sitting or standing when you entered George's room. Do you remember what position George's bed was? Was it up at 90 degrees, at a 45-degree angle, lying flat?
I see now my mind's going back to trying to envision something that I don't remember.
Okay. Was he sitting in his bed?
He was in his bed, yes.
And in his hospital room, it's an ICU room, right? Can you describe what was in the room besides the people? You know, there's a bed, there's a table. What else is in the room that you can remember?
Well, I didn't remember him being in an ICU room, so I don't know which ICU he was in. If he was in the medical ICU, that would have been one of my assigned units, and I can describe those rooms.
Let me ask you this, in a medical ICU unit, are there typically more than just a bed and a chair?
Part of that depends on the amount, it depends on the size of the room, it depends on the amount of additional equipment that's being used.
Do you remember if George was on oxygen on February 9th, 2022?
I don't remember.
The medical records indicate that he was on high flow oxygen, I think 50 to 60 liters. Would that suggest that he would have a nasal cannula or a mask in your experience?
And honestly, that aspect of is medical, and I wouldn't know.
When you were talking to George, did he act like he was short of breath?
Not that I recall.
Did he string a lot of words together?
I'm not sure I understand.
Well, earlier you testified he was answering in yeses and no, correct?
Yes.
And kind of movement of his head and nonverbal communication. Is that a fair statement?
He verbalized his yes and no answers. I know he spoke briefly, he and the attorney, but I don't really recall what they said.
When you say briefly, for 30 seconds?
Maybe.
Would it surprise you, well, sorry, that you are not aware of medications he was on?
No.
You didn't ask the doctors what medications he was on that day?
That's out of our lane.
But you're signing a will in an ICU, correct?
Yes, ma'am.
There's, in your experience, I presume, that people in ICUs are on medication.
Yes.
And you know that some medications can affect somebody's ability to think rationally.
Yes.
And you didn't think it was important to ask a nurse or doctor if he was on any of those medications?
Well, as I stated, that's medical.
Objection, non-responsive.
Overruled.
You're having him sign a will that is based upon his capacity, correct?
Yes, ma'am.
And you didn't think it was important to ask anybody about medications that could alter his capacity or his thinking, correct?
Had there been any indication that he wasn't clear, I would have asked, as I stated earlier.
But you understand medications can affect somebody's thinking.
Sure.
Are you aware that he was being prescribed a sedative over the course of those days?
No way I could have known that, ma'am.
Would that have changed whether or not there was a red flag for you?
No, I mean, I wouldn't have, there's no way I would have known that.
That's not my question. If you knew he was being prescribed a sedative and administered that sedative over the course of the days and on the day he was signing the will, would that have caused a red flag?
If I knew that prior to entering the room for him to sign, yes.
Thank you. Did you see a laptop or a computer in George's room that day to your recollection?
Not that I recall.
Did you see a scanner in his room?
Not that I recall.
Did you have any substantive conversation with George on February 9th, 2020? Substantive being about his kids, his wife, his assets, anything like that?
Not that I remember. I remember that, as I stated earlier, that being a pretty brief visit.
And you said about 15 minutes?
At the most.
Is it fair that the attorney did most of the talking?
Yes. Yes.
That is fair. When you have access to medical records, correct? Or no?
We do.
Are you aware that George told his doctors that thinking about his business and the state plan was giving him anxiety?
No, I wasn't.
When you entered the room on February 9th, were you wearing a mask or was anybody else there wearing a mask?
Which visit
February.
of the three?
The will sign date.
My memory, no one was married.
Do you know, I know when's the last day that you worked at Methodist?
Wow, would have been mid-August of 23.
And I'm asking you to go back to February 9th, 2022, so bear with me.
No,
Do you remember if there were any restrictions on the medical ICU at that point in time for visitors?
for visitors, none beyond the restrictions that are part of the unit policy.
And do you know what that unit policy is or was at the time?
I don't remember the specifics.
And what made you decide to leave Methodist?
I had a series of real difficult situations in my personal life. And we had a new director came in that I wasn't wild about.
Is it fair to say that as we sit here today, remembering what exactly happened on February 9th is difficult?
Remembering it?
Remembering the details of February.
To some degree, yes, and that's why, as I mentioned earlier, I've leaned heavily upon the affidavit that I.
And even at that point in time, you admitted that you didn't specifically recall all of the facts, because that was about 15 months after, correct?
Correct.
And let me go back to one last thing. Was it your testimony earlier that Monty and Jessica were in the room when you arrived? Or Jessica last or the other witness?
Jessica was, and as I recall, the attorney was as well.
Smith?
I think Ms. Bobadi covered most of my questions, but I do have just a couple. Mr. Hawkins, my name is Laurel Smith. I represent Dorothea Polidoros and Christy Spitball, sitting right next to me. You did not know George Polidoros before he entered the hospital, correct?
Correct.
And you didn't begin meeting with him until February of 2022. Is that fair?
Until his admission?
Well, I don't believe there's any record of your meeting with him prior to February.
Oh, correct, that's correct.
Okay. Because you said earlier you recalled 3 meetings, one on February 2nd, 4th, and 8th, I believe. Is that right?
Actually, I only recall 2. I learned from counsel that there was a third, which is not surprising. Right.
Isn't it true that in addition to the will signing, there were 3 separate visits that you met with him that first week of February in the records?
I'm assuming it's the 3 that are noted there in the charting?
Yes, sir.
Okay, yes.
Okay. And none of those entries provide details of your visits with Mr. Polidoros. Is that fair?
Apparently, yes, that's fair.
Okay. And your only experience with Mr. Polidoros was pretty much that maybe 2-week period of time where you saw him in his hospital room.
Correct.
So you have no baseline of how he was, what his physical condition or his mental condition was prior to his admission in the hospital. Is that fair?
That's fair.
Okay. So other than the interactions that you had in the hospital, you have nothing to compare that to prior to that to know whether or not he was confused as to anything in his life, right?
Correct.
That's the way to.
Redirect.
Thank you. Thank you, Chuck.
Is the witness subject to recall by anybody? Can we excuse him for,
Good call.
can we excuse him for the, okay. Thank you, Chaplain.
Yes, sir.
For the duration of the trial, you may return to work. Thank you, sir. All right. I'd like to call your next witness.
Just go ask.
All right.
Jessica Baxter.
Y'all doing okay? You need a stretch? You want to stand up and stretch a little bit before you go to this next one? You can do that. 7th inning stretch. Oh. Didn't mean to do that. You can also, I'm going to stretch. If you don't want to, that's fine.
Restraint. Having it 7. There you go.
You may stretch, yes, absolutely. Come on over here. We're just stretching right now. It's been a little bit. Do you solemnly swear or affirm the testimony about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. All right, Mr. Cook.
Ms. Lasker, would you please state your name, let the jury know you
Hi, my name is Jessica Laster.
are. Okay. Have you ever testified before?
No, I have not.
Are you nervous at all?
A little bit.
Okay, that's fair. There's a document in front of you, and there's just a couple of questions I have to knock out really quick.
Okay.
Have you seen that document?
Yes.
Okay. We take a look at it, and look at the last pages. Do you see your signature on that document?
Yes.
Okay. Do you see anybody else's signature on that document?
Chuck. I think that's Chuck. It's my name and then it's a CD. I'm just guessing. It's Chuck's.
Chuck's name. All right. And then anybody else?
George's name, George Polidor's name is signed at the top.
Okay. And were you in the room when George signed that document?
Correct.
And was Chuck in the room too at the same time?
Yes.
And did you and Chuck sign in front of Mr. Polydor's?
Correct.
And did Mr. Polydor see you guys sign that?
Yes.
Okay. All right. You can set it aside.
Okay.
All right. Tell me, where are you from?
I'm from Houston.
Okay. Which go to high school?
Ebony Worthing High
Okay.
School.
All right. Where are you working now?
Still work at Houston Methodist Hospital.
Okay. Is that the same place you were working when you witnessed this one?
Yes, sir.
Okay. All right. Do you recall when you were asked to serve as a witness to this will?
Correct. Yes.
Okay. What happened?
I worked the front desk, I'm administrative assistant. Chuck came to the desk and asked if I could be a witness to a document. It's always busy. I work in the ICU.
Okay,
Chuck was our chaplain at the time.
Right.
So I went to the room. It was just me, Chuck, and a, lawyer.
okay, and George Polydorus was there?
He was the patient, yes.
Okay. This is Lisa Polydorus. Was she in the room?
No,
How long did this meeting last?
for me, not long,
Okay,
because I can't leave my desk for a long period of time. So I had someone watching the desk while I run to the patient room.
okay.
Had this encounter, then came back to the room. So for me, it maybe 5 minutes.
Let me ask you this, when you were in the room, was the attorney and George Polydorus talking?
Yes, they was having a conversation.
And I'm gonna ask you, was it a conversation or was it ahas and nos?
It was a conversation.
Okay,
I'm sorry.
Objection.
Objection leading.
Sustained as to both. All right, you want to rephrase your question?
just trying to get a sense of whether it was a conversation back and forth.
A conversation back and forth.
Okay, do you remember what they were talking about?
I don't.
Okay. When George and his attorney were having a conversation, did it appear to you that he was confused?
No,
Right. Did it appear to you that he was on any kind of medication?
no,
Did it appear to you that he was laboring, struggling physically to be in the room and talk to everybody?
no,
Was there anything that gave you pause to sign as a will to George's, sign as a witness to George's will?
no,
Did you ever seem confused? Did George Polydorus ever seem confused during this period of time when he was conversing with the attorney?
no.
A past witness.
Ms. Quabavia?
Ms. Officer, I don't know that I will be as quick as Mr. Cook, but I will try to be quick.
No problem.
And thank you for being here today. I have been in the witness stand when I've served as fiduciary, and it's nerve-wracking even when you're. Have you watched any live streams of this?
No.
And have you ever met Miss Lisa Polydorus?
No, not that I can think of.
And you testified that your position at Houston Methodist is an administrative assistant, and that's in the intensive care unit.
Correct.
And was George Polydorus a patient on the intensive care unit on February 9th?
Yes.
And how often did you work with Fred Hawkins?
I've been in medical ICU maybe for the last 5 years. So he was the chaplain there when I started in that unit.
Did you know him fairly well?
Passing, speaking every day. He would come on our unit every morning.
And so you just testified that Chuck asked you to be a witness, correct?
Mhm.
When did he ask you to be a witness for the will?
Maybe, I don't know exactly what time, because it's always busy on our unit, but he just came to the desk and said, hey, can you be a witness?
And that was on February 9th, 2022?
Yes.
When you went in the room, who was in the room?
It was the patient, it was the lawyer, it was me and Chuck.
Did Chuck enter the room before or after you?
Chuck was in the room before me.
And you said that this lasted 5 minutes at the most?
For me, it lasted 5 minutes.
The will signing ceremony?
The will signing ceremony, yes.
Okay, lasted 5 minutes?
Mhm.
And did you know anything about Mr. Polydorus before you witnessed as well?
No, I don't.
Had you ever talked to him before?
No.
Had you, this is gonna sound like a silly follow-up question, had you ever met him before?
No, other than maybe calling on a call like, I pick up the phone, hi, how can I assist you? I need my nurse. Other than that, no.
No other reason to go into his room?
No.
And as a unit secretary, if you have to go into somebody's room, do you have to make any notations in any record for the hospital?
Yes,
And did you make that notation for February 9th?
I did not.
You did not.
It was a quick encounter.
So are you not required to make a notation?
No.
Are you required to notify the hospital if you witness any legal documents? Did you notify the, I'm sorry, I didn't let you finish.
Oh, no, it's okay. Yes, I did notify the hospital.
And is there a record of that?
Yes,
And did you add any, editorial to that? Did you add anything other than I signed this document?
no,
Had you ever met George Polidorus before the will signing?
no, other than,
And never met him before the hospital?
no, never met him before the hospital.
So you have no idea what his baseline was outside of the hospital, correct?
No, I can't speak on his baseline.
Was anybody, including yourself, wearing a mask on the day of the ceremony?
I can't remember.
Do you remember if there were restrictions for visitors on the COVID ICU on February 9th, 2022? I'm sorry, and I said COVID ICU for patients who had COVID on the ICU.
Our visitation is already limited to 2 people at a time, regardless if they have COVID or if they have any restrictions. They can still come in, but they would have to, it matters on the isolation. So it would have an isolation sign on the window that would tell you have to gown up, wash your hands, wear a mask. So it's at the discretion of the visitors if they would like to come and visit, but it's only 2 visitors at the bedside at a time.
Okay, so it's 2 visitors in the ICU at bedside, so they can be in the room together.
Ma'am,
They can be in the room together.
they can be in the room together.
Perfect, thank you. When you witnessed Mr. Polidorus's will, do you remember if he was wearing glasses?
I can't remember.
What about hearing aids?
I can't remember.
And a hearing amplifier, you know, a larger amplifier outside the ear.
I can't.
Okay. Other than signing the will, do you have any real specific recollection of that 5 minutes of your life?
No, ma'am.
And did you speak to George's doctors on February 9th, 2022?
No, ma'am.
His nurses?
I probably did for what I do on a daily basis.
But nothing regarding the school site?
No,
Okay. Do you know if George was on any medication on February 9th?
I can't speak on that.
Okay. Do you know if he was on oxygen on February 9th, 2022?
Remember?
Okay. Do you remember when you went into George's room if he had a nose cannula or a face mask?
I don't remember.
Do you remember if there was a computer in his room?
Yes, there is. It's a computer in every room.
But that's the hospital computer.
Yes, it's the hospital's computer.
Do you remember seeing a personal computer anywhere?
No, ma'am.
Okay, do you remember seeing a scanner anywhere?
It's a scanner in every room.
The hospital scanner?
Yes.
I'm asking really bad questions. I'm sorry. Did you see a personal scanner in every room? Or his room, not every room?
No, ma'am.
Okay, thank you. Did George ever explain to you anything in his will?
No, ma'am.
Okay, did he ever talk to you about his kids?
No, ma'am.
Did he ever talk to you about his wife?
No, ma'am.
Did he ever talk to you about any of his assets?
No, ma'am.
Excellent.
Ms. Smith.
Ms. Laster, when you were in George's room, do you recall seeing an IV in his arm?
Yes, ma'am.
Isn't it fair to think that if he had an IV in his arm, he might be getting med?
As I stated before, I can't speak on what medication is being ran because I'm not sure. As I stated, I was in there maybe 5 minutes.
Objection, non-responsive.
Fairly responsive. If you want to clarify the
I'll
question.
re-ask the question.
Mhm.
If a person is in an ICU with an IV in their arm, isn't it possible that they are receiving medication through that IV?
It is possible, but I can't speak on what medication it is because it also can be like, it can be liquid if they're dehydrated or something like that.
Right. But you didn't think to ask anyone if he was on any intravenous medication at that time?
No, ma'am.
Okay. And would it surprise you to know that he was actually on intravenous medication on that date?
As I stated, I'm not sure exactly what medication he was on because I just went in the room because someone asked me, could I be a witness? And as I stated, I didn't stop to think to ask the nurse, hey, what medication is he on or anything. I was just trying to go in real quick and come out.
You didn't speak to any of his doctors?
No, ma'am.
You didn't inquire any questions as to his ability to sign this document?
No, ma'am.
And you testified earlier that visitation allows only 2 people at a bedside at a time, is that right? Is that what the policy is today?
Yes, ma'am.
And do you recall what the policy was in February of 2020?
It's the same.
It was the same.
Mhm.
Okay. And it's not a common part of your duties with the hospital to execute wills as a witness. Is that fair?
Correct.
How many wills have you executed in your capacity as an administrative assistant?
This was my first.
Have there been any since?
No.
Okay, pass the witness.
Thank you, Ms. Clapp. I have any more questions for you.
Is witness subject to recall by anybody?
No.
No? Thank you so much.
Thank
You're
you.
excused for from the trial entirely.
Okay, thank you so much.
Thank you. Are we standing now?
Oh,
Good. All right. I think that concludes the testimony for today. Is that correct?
I think so.
Okay, all right. So let me go ahead and give some instructions to the jury before we dismiss them. Tomorrow morning, you'll have breakfast taquitos. Is there any special request? Brother is really good, but that line is so long. But I tell you what, I will try for you. I will try for you to get some brothers. Yeah, okay, all right. So when I go to Brothers, I usually get tocino, egg and bacon, chorizo, and just a regular potato and egg. Is that good? Everybody good? Ground beef too. Special request? You got it. You got it. All right. Sorry. No jalapenos? Okay, we can do that. We can do that. All right. So remember what I told you. As always, you can't talk about this to anyone, not even somebody very close to you. Don't post about this. Don't say anything. And don't talk amongst each other about this. You can talk about the weather, whatever you want, but not each other until it is fully submitted to you. Also, again, keep an open mind. You haven't heard everything yet, right? And every time you think you're going one way, you hear somebody else do something, you might be going the other way. So just remember that goes back and forth until the very, very end. So keep an open mind. Don't draw any conclusions. If you feel yourself drawing a conclusion, just stop yourself and say, I'm not supposed to do that. Any questions before we leave today? Yes, ma'am. Yeah, we'll start at 9 o'clock in the morning, but I'll have the taquitos ready about 8:30. Okay, if you want to get here a little bit early and have some breakfast, okay? Yes, ma'am. No, we don't do this on weekends at all. No. Well, at least I won't be here anyway. All right, any other questions? If you want to be here today, I'm here at 7:30. So if you want to come here early, you're welcome to. It'll be open. You'll have coffee. But yeah, I'll have the taquitos ready about 8:30. I'll go to Brothers. I'll get the stuff you want. So they're gonna make me work for this, aren't they? I was just gonna go to Taco Cabana. All right. So if there's nothing else, you're all dismissed for the day.
All right, for the jury.
Do we need to talk about anything?
I don't think so.
No? Would anybody care to have an observation about non-responsive objections from the view of the bench?
Yes, sir.
Sit down. No, it's not. This is not on the record. It's just kind of views from the bench if they want. Non-responsive objection is typically accompanied by something else that follows it, such as a jury instruction. Please, would you mind instructing the jury not to answer any or not to consider anything beyond X, whatever that X is. You can ask the judge to instruct the witness on the reason for a non-responsive objection, which is, witness, listen carefully to the question, answer just the question, and don't volunteer any extra information. You can ask me to do that, and I'll be happy to do that. And sometimes, even though an answer really is non-responsive, it may be better just to do one of two things, just follow up with a different question to try to get the answer that you really need to get clarification rather than objecting to non-responsive. Or if they are going into a very long narrative, you can interrupt them and say, okay, wait a minute, the judge, this is, he's giving a narrative, or it's non-responsive, those kinds of things. And the only reason I say that is because the jury has no idea what to do with that kind of an objection. They don't know what the effect of it is. And so does that make sense? Is that helpful?
Yes, perfect.
So I'm not saying don't do it. I'm just saying, here's kind of how I see it in this particular court. Maybe other courts are different. I don't know. All right. Have a great evening, everybody. I'll be here with expensive Brothers tacos. All right. So that concludes our